All right, I think that's been corrected. All right. Good morning, ladies and gentlemen. My name is Judge Lal, and we are going to begin with the Fulton State All-Purpose Calendar. This is a list of criminal misdemeanor cases in which individuals have already been accused, bonds have already been set, and today would be technically what we call a plea and arraignment calendar, as well as other miscellaneous matters. If you are a defendant charged with one or more misdemeanor offenses, please remember these rights. The first one is the right to remain silent. Anything you say about the facts of your case, especially during the course of this recorded live stream proceeding, your statements shall be used against you. So do not say anything and let your attorney speak on your behalf. You have a right to an attorney. If you cannot afford one, one will be representing you from the Public Defender's Office or the Conflict Defense List. So we're going to begin with courtroom 2.
Yeah,
And
good morning, Judge Law.
good morning, Deputy Francois. Who do we have?
Going to be position 17, Mr. Page.
Okay. Position 17 is represented by Ms. Doties, and this is going to be a negotiated plea. Are we ready to proceed? Counsel?
Sorry, yes, Your Honor. We just need to confirm the jail time. And it'll be a negotiated plea. I believe it should be 16 days.
Yes, I'm trying to confirm that jail time now. I think it might be 18 days.
Okay.
Let's see now. This is position number 17. How long has he been in custody?
16 days, Judge.
16 days.
Okay, so the jail time is 16 days then?
Yes, that's correct, Your Honor.
Okay.
And with that, we're ready to go forward with the negotiated plea, Your Honor.
All right. Mr. Doties, are you in the courtroom too?
Yes, I am, Judge Law.
Oh, okay. Sorry, I'm just wanting to be sure. Thank you.
That's okay.
All right. All right. This is State versus Cedric Page, case number 22 CR 008516G. Mr. Page was accused of battery, domestic violence from an August 18, 2022 incident. Mr. Page, you've been advised of your right to remain silent. Your attorney is Mr. Doties. Now we are going to address a negotiated plea. So may I place you under oath? Mr. Page, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. Mr. Abdullah, what are the terms of the plea?
Yes, the state is recommending 12 months, 60 days to serve, credit for time served, 16 days, balance probated. The state is asking the defendant undergo mental health evaluation and treatment, 24 weeks family violence prevention, a stay away from 380 Martin Street, which is the incident location, and no further contact with the victim, Karen Dennis, common spelling.
Repeat the last name.
Karen Dennis.
Dennis. Okay. Thank you. And the 24-week program is the standard 6-month domestic violence intervention program, correct?
Yes.
Okay. Mr. Doties, has your client agreed to these terms, and do you stipulate to the factual basis, venue, and ID?
He has, and we do so stipulate. Your Honor, we would ask for probation fees to be waived, and if the state is agreeable for Mr. Page to switch to non-reporting status upon completion of the FVIP class.
All right. I will waive probation fees from, let me see, this is the beginning of January. So I'll waive it through the end of September 2023.
Thank you.
And if he completes the classes and the MH evaluation with no retreatment required, I'll put the probation on non-reporting. Would that be satisfactory?
Yes, Your Honor.
The state has no objection to that.
All right, thank you, Mr. Abdullah. Mr. Page, have you consumed any medication or alcohol recently?
No.
And have you, are you satisfied with your attorney services?
Yeah.
You need to answer clearly because there's someone talking in your room, okay?
Say yes.
And have you understood everything that's been going on so far in this case?
Yes.
Repeat.
Yes.
Mr. Page, is anyone forcing you or inducing you to take the plea recommendation by the state?
No.
If you decide to move forward and plead guilty to this charge, you would have to give up your right to go back to court, have a trial in front of a judge or a jury, to be able to confront your accuser, challenge the state's evidence, present any defenses if you choose to do so, and have the state try to prove the charge against you beyond a reasonable doubt. Do you understand these rights that you're waiving?
I understand.
Do you so waive these rights?
Yes.
How do you plead to one count of battery, domestic violence?
Yes.
I accept your guilty plea. Your sentence is 12 months to serve 60 days, credit for time served, 16 days. I believe that would leave you with an additional 16 days left to serve at the Fulton County Jail. Would that be correct? Mr. Doties?
Yes.
I believe so, Your Honor.
After you completed the additional 16 days, you'll be released and placed on probation. Your probation fees shall be waived up to and including the end of September 2023. During that time, hopefully you will have completed your MH evaluation and subject yourself to any treatment that's required. You'll also need to complete the 6-month domestic violence intervention program classes at your expense, which is why we're waiving your probation fees for the first 8 months. At all times when your probation, reporting or non-reporting, you shall stay away from 380 Martin Luther King Jr. Drive in Atlanta and have no contact with Karen Dennis. Do you understand, sir?
I understand.
All right. That concludes this case.
Mr. Page, as soon as you complete these conditions, let us know. We're trying to move this out.
Positions 20 and 21, Mr. Salam.
All right, Mr. Doties, what is the announcement for this case?
I believe it's going to be a negotiated plea.
All right. Mr. Abu Welven Salam has 2 cases before us. Case number 22 CR 001590F, accused of criminal trespass from March 20th, 2022. The second case is 23 FTA 000007, failure to appear for a fingerprintable offense from September 6, 2022. And with regards to both these cases, Mr. Salam, you've been advised of your right to remain silent, and your attorney is going to be Mr. Doties. Mr. Abdullah, what are we doing with regards to the second case?
So the FTA, the state moves to no pros.
All right, thank you. So position 21 will be null prost, and please send the proposed order to our litigation manager. And so we are addressing a plea for position 20. Mr. Salam, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Abdullah, what are the terms of the plea?
The state recommends 12 months, 22 days to serve, credit for time served 11 days, balance suspended, and we just ask the defendant comply with all MARTA suspension.
Are we aware if he has any active suspensions going on?
He was under suspension. I'm not sure if it's still valid, but he may have been suspended again after this arrest.
Okay, thank you. Mr. Doties, does your client agree to these terms, and do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, and we do so stipulate.
Mr. Salam, have you consumed any medication or alcohol recently?
No.
And have you understood the proceedings so far?
No.
If you've not understood the proceedings, we can let you talk to your attorney again to understand what's going on.
Please do.
All right. Mr. Doties, does your client have any questions?
Okay, can I have a moment to speak with my client? Your
All
Honor?
right. You might want to mute courtroom too.
Thank you. What questions do you have?
Oh, yes. Okay.
We're ready to proceed, Your Honor. Thank you.
All right, thank you. As I was saying, Mr. Salam, have you understood the proceedings so far?
Yes,
And are you satisfied with your attorney's representation?
yes,
Is anyone forcing you or inducing you to take the plea offer today?
no,
If you decide to plead guilty to this charge, you would have to give up your right to go back to court, to have a trial, confront your accuser, challenge the state's evidence, present your own defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights? Mr. Salam, would you like me to repeat that?
no, not repeated.
I can't understand you, sir. Could you repeat?
No,
All right. You're not prepared to give up these rights?
I am prepared. Yes, I am.
Could you repeat your sentence again, please?
Yes, I am prepared.
Mr. Salam, if I don't understand what you are saying, and if I don't ascertain that you are willingly, voluntarily, and knowingly giving up your right to a trial and other constitutional rights, I will not accept this plea, and I will reset the case for another day. So it's very important that you speak up and answer the question clearly.
Yeah.
I'm going to ask you again. In order for me to accept your guilty plea to this charge, you must willingly and knowingly give up your right to a trial, to go back to court, to have a trial in front of a judge or a jury, to confront your accuser, examine witnesses, challenge the state's evidence, present your own defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes,
How do you plead to one count of criminal trespass?
guilty.
Your sentence is 12 months to serve 22 days, credit for time served 11 days. That concludes your jail time. The remainder of your sentence is suspended. You are to stay away from all Martyr property as long as there are active or is an active suspension against you. The way you would verify whether there is any active suspension against you is you would have to contact Martyr at their Lindbergh headquarters and verify that you are not under any active suspension. If you return to a Martyr property and there is an active suspension, you'll be arrested and brought back to jail. Do you understand, sir?
Yes,
Thank you. That concludes this case.
That's what Mr. Salam. That's what.
Position 26, Wiggle.
This is State versus Ernest Wiggles, charged with simple battery domestic violence in accusation number 22 CR 008523E. Mr. Wiggles, you have been advised of your right to remain silent, and you have also chosen to represent yourself. Is that still the status, Mr. Dodies?
As far as I know, Your Honor.
All right. Mr. Wiggles, if you have a right to appointed counsel. If you cannot afford one, one would be appointed to represent you. And in this case, we have a very able attorney, Mr. Dodies, who's ready, willing, and able to represent you. If you choose to represent yourself, please understand that you are charged with a violent crime, even though it's titled simple battery, is still an element of violence. If you choose to represent yourself, you have to understand how the law and criminal procedures apply to your case, and that any legal decision would be your responsibility as to how it impacts your personal situation, your job, or any other open cases that you may have against you. Would you still like to represent yourself, or would you like the assistance of an attorney?
I would like to represent myself now.
All right. Are you willingly, knowingly, and then voluntarily waiving your right to counsel?
Yes, ma'am, I am.
All right. Give me a moment here. All right, Mr. Wiggles, you've been accused of simple battery domestic violence from October 15th, 2022. The accusation was filed on December 27th, 2022, involving the alleged victim, Wanda Watts. And how would you like to proceed in your case today? Would you like to, well, let me first ask, Mr. Abdullah, has there been a plea offer made in this case?
There has, I'm not sure if it was given to the defendant, so I can read it for the record and give him.
You can go ahead and read it for the record, please.
Okay. The state is offering 12 months to serve, 180 days, credit for time served, 14 days, balance probated, 24-week family violence intervention, stay away from 945 Ralph David Abernathy, and no further contact with Wanda Watts.
That's Ralph David Abernathy. All right. You said credit for time served to serve how many days? 28 days?
To serve 180 days, there was 14 days
days.
credit for time served.
Okay, so sorry, I'm trying to do the math here. So it looks like he has about 75, 76 more days to serve.
Yeah, it's about 60 days. It's about 60 days left, I believe.
You're saying 12 months to serve 180 days?
1 second, I'm pulling out a calculator now. I think it will be 62 days remaining. That's with the credit for 1 for 2 days.
All right, I have that he's been in confinement for 16 days, so he would be given credit for 32 days. Okay. All right, so you believe it's 62 days. All right.
I have 14 days. It could be 16. Just let me verify his time served credit.
All right. The attorney who represented Mr. Wiggles at initial appearance was Miss Maureen McLeod. So Miss McLeod is on the Zoom. Mr. Wiggles, if you want to have her services.
Excuse me. Say it again.
The attorney who represented you at your initial appearance, when you first appeared in front of a judge, before Judge Morrow,
Yes,
and he set your bond at $5,000.
yes.
The attorney who was representing you at that time is Miss Maureen McLeod. She's on the Zoom. Do you see her?
Yes, I see her, ma'am.
All right. Would you like to have her continue representing you, or would you like to continue representing yourself?
May I speak with her before?
All right. Miss McLeod, do you have the jail's number?
I have several here, and I'm not sure which one they would want me to call.
Deputy Francois, could you repeat the jail number, please?
Yes, sure. It's gonna be 404-612-2392.
All right. And Ms. McLeod, the terms of the plea offer was 12 months to serve 180 days, credit for time served 16 days, balance probated, FWIP, stay away from 945 Ralph David Abernathy, and no contact with Wanda Watts.
Thank you.
All right, position 26 is going to be talking to Ms. McLeod.
Position 27, Williams.
Thank you.
That's McLeod as well.
Oh, that's McLeod as well. Okay, have a seat. We're gonna go back to you. Position 28, Tyler Williams.
Tyler Williams, all right. State versus Tyler Williams, case number 23 CR 000035A. Mr. Williams has been accused of marijuana less than 1 ounce from December 28th, 2022. This is going to be a negotiated plea. Mr. Williams, you're represented by Mr. Dodis, and you've been advised of your right to remain silent. Mr. Abdullah, what is the plea offer?
The state is recommending 12 months, 18 days to serve, credit for time served, 9 days balance probated, alcohol drug evaluation, and proof of employment.
All right. Why are we requiring him to be on probation and the alcohol and drug evaluation? What is it about this case?
It's a possession of marijuana case.
Understood? It's misdemeanor possession.
Yes, he also has a history of drug distribution and marijuana possession.
All right. Convictions?
No convictions. They're still open, Your Honor.
Oh, so he has other open cases involving controlled substances?
Yes, I believe it's 2 open cases out of Alabama for unlawful distribution of drugs and another marijuana possession from 2021.
All right. Mr. Dodis?
Yes, Your Honor. I spoke with my client yesterday. We went over the offer and all of his options, and we're prepared to go forward with the negotiated plea and stipulate to the factual basis, venue, and ID. We would ask for probation fees to be waived and for Mr. Williams to go non-reporting upon completion of this condition.
And when will he be able to report to probation? Is he on any holds right now? Does he need to be transported elsewhere or extradited to Alabama?
He has a hold in Alabama, I believe.
All right. Miss Champion, can you confirm that he's got a hold? Will he be transported to Alabama or will he be released and go on his own reconnaissance?
I don't think he'll be released. The charges out of Alabama were 2 felonies.
Okay.
Thank you.
I do see he's got a fugitive hold.
Yes, Your Honor, he does have a fugitive hold.
My goodness. Initial appearance was $100,000 bond. All right. Well, I don't see that too often, so there we go. All right, Mr. Williams, if you'd like to raise your right hand, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? You need to unmute courtroom 2, please.
Yes, ma'am.
Thank you. Mr. Williams, these are the terms of the offer. Your attorney has stipulated to the factual basis, venue, and ID. Have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
Is anyone forcing you to take this plea offer today?
No, ma'am.
And if you do so, you will not be able to come back to court, have a trial, challenge the state's evidence, confront your accuser, examine witnesses, and have the state try to prove this charge against you beyond a reasonable doubt.
I understand.
All right. Do you so waive your rights? Do you waive the rights I've just listed?
Yes, ma'am.
How do you plead to this misdemeanor count of possession of marijuana less than 1 ounce?
Yes, ma'am.
Repeat.
Do you plead guilty? Oh, yes, ma'am.
Again,
Yes, ma'am. She's asking to say guilty.
guilty or not guilty to the charge of misdemeanor possession of marijuana?
Guilty.
Your sentence is 12 months to serve 18 days, credit for time served 9 days. Your jail time for this case is completed. The state is asking that you are placed on probation and to complete an alcohol and drug evaluation. Once your cases in Alabama are resolved, you'll need to come back to Georgia and go on probation and complete the alcohol and drug evaluation. If you complete one in Alabama, make sure you report that to Georgia. And once the evaluation is completed, as well as any treatment, your probation will terminate.
Yes, ma'am.
Thank you.
Your Honor, did you mention terminating any probation or waiving any probation fees? I apologize. If I misheard.
No, it's just
Okay.
an alcohol and drug evaluation. He'll be able to get that done. And I
Thank
don't
you, Your
know
Honor.
when.
That's working with them.
Prosecutor Ian Walker is asking if there's an attorney for Sanchez Martinez on the Zoom. Don't know. All right. Moving on, Francois, who do we have, please?
Position 25.
Duffy, check your chat.
All right.
Duffy,
Yes, I see it.
okay,
I will go there next.
okay.
Oh, I'm sorry. 5 North, is that position, is that Khalid Tillery?
Yes, ma'am.
All right. Mr. Tillery, your case number is 21 CR 001-945Y. You were accused of simple battery domestic violence from April 17, 2021. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have appointed counsel, Mr. Dodies. Do you see Mr. Dodies? He is in courtroom number 2 on the screen. Mr. Dodies, if you could wave your hand, please. Do you see him?
Yes, ma'am.
All right. So, Mr. Tillery, that is your attorney. You've had an opportunity to speak with him?
Yes.
All right. And I understand this is going to be a non-negotiated plea, which means that the prosecutor is going to let me know what kind of recommendation they're offering. And then your attorney will let me know what is the alternate that you are seeking. I will make a decision as to which option I'm going to elect, keeping in mind that I also have a right to disregard the plea and set this case down for trial. Do you understand?
Yes, ma'am.
Thank you. Ms. Campbell?
Yes, Your Honor. The state's recommendation for this case is 12 months to serve 180 days. Credit for the time served 32 days. The balance is to be probated. He's to complete a 24-week family violence intervention program as a condition of his probation. He's also to provide proof of employment as a condition of his probation, as well as he is to have no further contact with the victim, and her name is Mikita Edie, and that's spelled M-I-K-I-E-T-A. And he is to stay away from the location of 1847 Childress Drive, which is the incident location.
All right, that's in Atlanta?
Yes, Your Honor.
All right, thank you. Okay, Mr. Dodies, that is what the state is seeking. What is the defense seeking?
Yes, Your Honor. We have 2 concerns, the first being jail time and the first being the FVIP program. For jail time, I calculated the jail time, and he has been held on this charge for a total of 86 days. So we just wanted to make sure that Mr. Tillery is getting all of the time served or the credit he is owed for this. On this most recent arrest, I think he's only gotten 34 days around that. So that might be what the state is thinking. But in total on Odyssey, I did the math yesterday, and as of today, it should be 86 days. So we agreed to the serving 180 days with credit for that 86 days. So after county time, that would give Mr. Tillery 4 more days to serve. Regarding the Family Violence Intervention Program, while still in custody on December 22nd, Mr. Tillery, in case number 22 CR 000790Y, pled guilty to cruelty to children in the 3rd degree and 1 count of battery family violence. And as one of the conditions of that plea, he was to complete an 8-week anger management full term for his probation. And so we're just asking, I don't want to set Mr. Tillery up for failure. And so we're asking for the court to just have the conditions run concurrent to that prior plea, or worded in a way where he'd only have to do that 8 weeks of anger management. So we're not setting Mr. Tillery up for failure with too many conditions in place. I think the 8-week anger management, once he's released on all of these charges, will suffice for Mr. Tillery. So once the jail time and the conditions are settled, we're we're fine with everything else that's been offered by the state.
All right. I'm looking at the warrant. I'm looking at his procedural history in this case. I do see that he's been in custody for 47 days, but that's also pursuant to additional, like you said, the additional felony charges that came into play from the February 15, 2022 incident. This case involves a 2021 incident. The time that he served in this particular case initially was 4 days from the time of arrest until he was given a signature bond. He subsequently failed to appear in court. His bond was forfeited, a cash bond was instituted, and then he acquired a felony case less than a year later. Under the circumstances, given Mr. Tillery's disturbing criminal record history, just in Fulton County alone, I don't believe that the term set forth by the prosecution is set up for Mr. Tillery to fail. Mr. Tillery's situation is such that he has placed himself in this position, and if he wants to accept the plea offer from the state, requiring the additional jail time, requiring probation, and definitely requiring the 6-month domestic violence program classes, considering his record, the 8-week anger management classes is just not going to cut it. So I'm accepting the state's recommendation. And if Mr. Tillery does not want to move forward with the plea offer, I am more than happy to set this case down for trial.
Okay.
Can we unmute 5 North, please? Mr. Tillery, I'm not accepting the defense recommendation. I'm accepting the state's recommendation that you serve 180 days. You're given credit. I'm going to give you credit for 47 days, not 32, but you will be serving additional jail time. Your prior condition for 8 weeks of anger management classes, you may do that because you do have that issue with Superior Court in your felony case. But the domestic violence program classes, that is specifically tailored for family violence convictions, which is what you're facing. So if you want to proceed, I'll be sentencing you under the state's recommendation. Otherwise, your other option would be to plead not guilty and we proceed with trial. What would you like to do?
Proceed with the prosecution's suggestion.
Mr. Dodies, are you comfortable that we shall proceed?
Yes, Your Honor. If I could just have, I just want to confirm my only issue is with the jail time. I looked at Odyssey myself, and I believe on 3 separate times, Mr. Tillery was receiving credit for this case. The most recent being for 35 days, then 47 days, and 4 days on his initial arrest. So I have 3 separate jail terms on Odyssey, and I just want to make sure he's getting the correct credit.
Oh, I'm giving him the credit. I'm already giving him some partial credit, but I'm also attributing some of that time to his felony arrest for, and the felony arrest, let me see, this is Ms. Tillery. We have July 20th, 2022, battery domestic violence. We have July 20th, 2022, terroristic threats, another simple battery domestic violence. That was for this particular case. And then we have the February 15, 2022 for cruelty to children in the 3rd degree and battery domestic violence. So it's either going to be 47 days or the 32 days the state's asking for. Which one would you like? I'm not giving him more time.
All right, Mr. Tillery, so you're getting credit for 47 days. The offer is to serve 180 days. So county time would be like another 45 days. Do you want to go forward with this plea?
All right, we will let him think about it and move on to the next.
I want to go for it.
All right. So, Mr. Khalid Tillery, as I've already said, you do have a right to remain silent and you have a right to an attorney, and you presently have also a right to accept the plea offer from this negotiated plea, non-negotiated plea, excuse me. Keeping in mind that that you will be serving additional jail time. We haven't exactly done the math on this. So it's 180 days. I'm giving him credit for 47 days, which means that 4, 8, 9. Ms. Champion or Mr. Doties or Mr.
I
McClain?
got 43 days, Judge.
Okay, so he's got additional 43 days left to serve at the Fulton County Jail. Mr. Doties, would that be correct?
I don't have a calculator, but that sounds right to me.
I'm doing simple math, so you literally, I'm not using one either.
I
so.
calculated up, Judge. It's 40. It's that time I gave you. This is Katrina.
Thank you, Ms. Lewis. All right, 43 days is how much time is left. So, Mr. Tillery, I'm asking you for the last time. Is this something you'd like to accept?
Yes, ma'am.
And you do understand that once you are completed the jail time, in addition to serving out your sentence for the felony case, you also have to go for the 6-month domestic violence classes at your expense.
Yes, ma'am.
And I'm going to require you to start those classes within 60 days of being released.
Yes, ma'am.
All right. Mr. Doties, do you stipulate to the factual basis, venue, and ID in this case?
Yes, Your Honor. For the purposes of this plea, we do.
All right. Mr. Tillery, please raise your right hand. You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, ma'am.
All right. Mr. Tillery, have you consumed any medication or alcohol recently?
No.
And have you understood the proceedings so far?
Yes.
Are you satisfied with your attorney?
Yes.
And has anyone forced you or induced you to take the plea today?
No.
All right. Just 1 second. Could the gentleman behind you please keep it to a dull roar? Thank you. All right. Mr. Tillery, has your attorney explained to you the waiver of rights?
Yes.
And you do understand that if you decide to plead guilty to this charge, that you would have to give up your right to a trial before a judge or a jury, to go back to court to confront your accuser, have the opportunity to examine witnesses, challenge the state's evidence, present any defenses if you choose to do so, as well as have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
You do understand that this could have impact upon any other open cases you have against you?
Yes, ma'am.
And you do not have a right to file an appeal from this decision. Do you understand that?
Yes.
How do you plead to 1 count of simple battery domestic violence?
Guilty.
Your sentence is 12 months to serve 180 days, credit for time served, 47 days. The remainder of the time you'll be on probation. You'll pay your probation fees starting September 1st, 2023. I'm waiving your probation fees all the way through at the end of August 2023. While you're on probation, you will enroll in a domestic violence intervention program that is a 24-week program, and you must do so within 60 days of being released from the county jail. While you are also on probation, you will show proof of employment within 90 days of being released from the county jail. Do you understand?
Yes, ma'am.
Failure to show proof of employment can be a basis to revoke your probation. At all times while you're on probation, you shall have no contact with McGee, Edie, and to stay away from 1847 Childress Drive in Atlanta, Georgia. After August of 2023, you will continue to report probation and start paying probation fees from September 1st, 2023 onwards. Thank you.
Thank you.
Excuse me, Judge.
Yeah.
I'm trying to find out which courtroom is the person that needs a Spanish interpreter. Their attorney is on the line and they're asking for a breakout room with them and a Spanish interpreter.
That's gonna be on 4 North. Officer,
4 North is not online yet.
Okay, thank you, Ms. Lewis.
Thank you.
Courtroom 2, who do we have?
this is going back to position number 26, Wiggles.
All right. Ms. McLeod, are you representing Mr. Wiggles?
I am, Your Honor.
All right, then does he like to proceed with the plea?
Your Honor, he wants it to be a negotiated plea.
I'm sorry, 5 North, could we mute the screen, please? Could the host, thank you. Ms. McLeod, could you repeat that response, please?
Mr. Wiggles would like to do a non-negotiated plea, Your Honor.
Okay. All right, Mr. Wiggles, we're going back to case 22 CR 008523E. Mr. Wiggles has been advised of his right to remain silent, and his attorney is Ms. Maureen McLeod. Mr. Wiggles, we are first going to hear, we've already heard from the prosecution, and Ms. McLeod, we've already also repeated the plea offer from the prosecution. What is this defense seeking?
The defense is seeking credit for time served that he already has, Your Honor. The family violence intervention program, the 24 weeks, we think that that is too long. And those are essentially the two things.
All right, so so the state's asking for 180 days to, credit for time served 14 days. And you are seeking to have no additional jail time. Is that correct?
That is correct, Your Honor. He is employed. He was employed before he came in. He had 3 different jobs. You know, he has not been around this young lady. His contention is that she came and sought him out and he tried to get away from her. And she just kept following him because he was with his new girlfriend.
Okay. Just one second. Mr. Wiggles, Ms. McLeod is your attorney and she's speaking on your behalf. But before I let you speak, I need to know who my pretrial officer is. Do I have a pretrial officer present?
It doesn't look like you have one. Let me see
Okay.
who that.
I'm here. My computer was frozen. I'm sorry.
No problem. Ms. Huggins, may I have Mr. Wiggles' GCIC, please?
Yes, ma'am. Your Honor, it looks like he has a total of 41 cycles. It does look like he has a theft by shoplifting case that is open in Fulton County. More recently on the GCIC, it looks like he has a battery family violence first offense conviction for 11/7/2022. It looks like he was given 3 years probation according to the GCIC. He has a couple of failure to appears on the GCIC, and I'm going up the GCIC really quick, Your Honor.
Do you have the case number for the battery family violence conviction from November 2022?
Yes, it is 22 SC 180326.
All right, let me just check what were the terms of you said it was a conviction?
Yes, it says guilty, convicted, disposition 11/7/2022, according to the GCIC.
All right, that was all right. This was a negotiated plea, 3 years probation.
He's still on probation, Your Honor, and he tells me I'm doing everything that according to the terms of his probation.
When did he begin probation?
He just started it recently. That is my understanding, Your Honor.
All right. All right, Mr. Abdullah, it appears that based on the sentence that he received by Judge Glanville, he has to complete the Family Violence Intervention Program. I am going to require him, I mean, if the state's requiring him to complete a Family Violence Intervention Program as well, I can make it concurrent with his Superior Court disposition as well. So the classes that he needs to complete for that case, in other words, I'm not going to make him do the class twice.
Right, and the state has no objection to that. However, the jail time, as far as it being a credit for time served, since it's the state feels that just would be highly inappropriate considering the defendant's record. The defendant has a 41 cycle arrest record, primarily violent crimes. Again, like the defense counsel said, he's still on probation for a case involving the same victim. He also had another simple assault case with the same victim in 2020. So he has a history and a cycle of basically assaulting this same victim. And so we think that the 180 days is more than appropriate, if not somewhat lenient.
Your Honor, we disagree with the state's contention in that since more than a year ago, my client has not been in contact with this victim. He doesn't live with her. In fact, he tells me that he lives in a tent. He's been homeless. He stayed away from her and he works in the area where this alleged incident happened. And she approached him out of the blue when he was with another woman. This wasn't her home. It wasn't her workplace. It wasn't anything. He was out on the road and she came up to him.
So in that case, then, I'm going to disregard the plea offer then and simply set the case down for trial. You're asking me to accept the defense's recommendation on the grounds that he's innocent, that he was not the one who provoked this alleged altercation.
That's what he tells me, Your Honor.
And I cannot accept a plea offer based on that.
That's why I was trying to represent myself. If I can, I thought that's what I was doing.
All right. So, Mr. Wiggles, you want a trial then? You want to challenge this case?
I want to speak. That's what I want to do.
All right. You have a right to remain silent. And if you want to speak, please keep in mind that the prosecutor will use your statements against you.
Okay.
And I'm sure your attorney doesn't want you to speak.
I know, I understand that. But Your Honor, since the year and a half, 2 years ago, when I got this stay away order from Miss Watts, I left Miss Watts. Me and Miss Watts don't even stay together anymore. I haven't seen this lady in about a year and a half, close to 2 years. And she pops up out of nowhere while I'm on lunch break and started hitting me with water bottles, throwing sticks at me. And I do exactly what the court asked me to do, Your Honor. This is what I was told from the court. If she approaches you, Mr. Wiggles, tell her that you have a stay away order and walk away. And that's exactly what I did. That's exactly what I did. If there was a confrontation, Your Honor, I would have told my probation officer, but my probation officer has come to see me twice. I'm only trying to move on with my life. I'm not trying to keep on going on with this lady. I have moved on. I'm just trying to put my life back together.
All right. So, Mr. Wiggles, I'm going to stop you right there. I'm going to stop you right there. I understand, and you are legally presumed innocent of this charge. And I absolutely agree. Ms. McLeod, I'm not going to move forward with this plea offer. Mr. Tillery bona fidely believes that a trial, if he enters a plea, is simply just to get out of jail. So I think you need to consult with him and determine whether he wants a bench trial or whether he wants a jury trial.
I will do that, Your Honor.
All right. Mr. Tillery, Ms. McLeod is your attorney.
Your Honor, this is Mr. Wiggles.
Mr. Wiggles, Your Honor.
Oh, excuse me, Mr. Wiggles, Ms. McLeod is your attorney. And I genuinely believe that if you enter a plea today, that you're not doing so freely, but willingly and voluntarily, and that you would be you'll be making a guilty plea just to get out of jail.
Well, Your Honor, I'm willing to work this case today. I just
This
want.
is not,
I
no,
just-
no,
I
no,
just
no,
want-
no.
Listen, I just.
No, I'm done. I'm done.
I just want.
I'm going to schedule this case for trial. I'm going to schedule this case
So
for trial.
how long do I have to wait for that?
We're going to have to put you on a bench trial calendar. Mr. Abdullah, any comment?
No, I'm listening to you. I don't know what the calendar is for bench
Your Honor,
trials.
the sooner the better.
I'm at the mercy of the calendars according to Orca. So we're going to put you on the bench trial calendar as soon as as a date is available, and the bench trial calendars are coming up sooner than jury trials. All right?
So
Ms.
I'll
Lu-
give to further notice?
Yes. I cannot give you a date right now, but you're definitely I'm definitely not accepting your recommendation based on your criminal record history. Thank you.
Wow.
Plea disregarded. Set for bench trial. Ms. Champion, if you can place it on one of our Orca bench trial calendars, that would be very helpful.
Okay,
Thank you. 5
Position,
North, who do we have?
position 23 and 24.
Thank you.
And Your Honor, I'm sending a message in the chat real quick on that, but we're ready to go on 23 in just a moment.
So on Mr. Serrato, does Mr. Serrato speak English?
Yes. I need an interpreter who should be on the line.
He speak English, Your Honor.
He does? Okay.
Good
Yes,
morning,
ma'am.
Your Honor, interpreter here.
All right. Let me first ascertain whether Mr. Serrato needs the services of interpreter.
Señor Serrato,
Oh, go ahead.
señor Serrato, ¿usted necesita el servicio mío de intérprete?
Sí, está bien.
Yes, that's fine.
Mr. Jose Serrato, my name is Judge Law. Do you understand English?
Señor Serrato, mi nombre es la jueza, soy la jueza Lal. ¿Usted entiende inglés?
Sí.
Yes.
All right. Do you need the services of an interpreter, or can you proceed without one? Or can you proceed without one?
¿Necesita el servicio de un intérprete o puede proceder sin un intérprete?
That answer tells me we need an interpreter.
Esa respuesta me dice que necesitamos un intérprete.
All right. Ma'am, could you please raise your right hand?
Yes, ma'am.
Do you swear and affirm that the translation you provide will be a true and accurate translation with no changes or embellishments?
I do, Your Honor.
Thank you.
You're
All
welcome.
right. We have 2 cases with Mr. Jose Paz Serrato.
Tenemos 2 casos con el señor Paz Serrato.
First case is 19 CR 004672A, in which he's charged with battery, family violence, and cruelty in the 3rd degree.
Tenemos el caso 19 CR 004-672A, en donde hay un cargo por golpes y lesiones, violencia familiar y crueldad ante un menor.
That's from a May 19th, 2019 incident.
Y este incidente ocurrió el 19 de mayo del 2019.
The second case is 22 CR 001595A.
El segundo caso es 22 CR 001-595A.
It's a traffic case involving expired or no license on person, brake light violation, and giving false information to an officer.
Es una infracción de tránsito que incluye los cargos por falta de licencia de conducir o licencia vencida, incumplimiento de uso de la luz de freno o giro y por presentar un nombre inadecuado a la fuerza del orden.
You have a right to remain silent about the facts of the case. Any statements you make can and will be used against you. You have a right to an attorney, and Mr. Dodis is representing you.
Usted tiene el derecho a guardar silencio y todo lo que diga puede y será usado en su contra y tiene el derecho a la asistencia de su abogado y el señor abogado está presente en, I'm sorry, Your Honor, could I have the attorney's last name again?
Dodis, D-O-D-Y-S.
Thank you. Y el licenciado Dodis es su abogado.
All right. Mr. Dodis, how are we proceeding in position 23?
¿Cómo
Yes,
vamos a proceder con la posición 23, señor Dodis?
yes, Your Honor. For position 23, we will be waiving arraignment and proceeding with a jail jury, and I will submit all paperwork as soon as I get back to the office.
Vamos a renunciar a la sesión de vista incoatoria y para proceder ante una sesión de juicio en la que empezaré a comenzar en cuanto yo llegue a mi oficina.
So, Mr. Dodis, you will submit the paperwork. Your client is pleading not guilty and the case will be rescheduled for trial, correct?
Correct,
Entonces, ¿es correcto, señor Doris, que usted va a presentar el papeleo necesario? No va a haber una declaración de culpabilidad y vamos a darle una nueva cita para la nueva sesión. Eso es correcto.
And what about position 24?
Y la posición 24.
Yes, Your Honor. I was just chatting with Mr. Abdullah about position 24, and I believe we're going to go ahead with a negotiated plea.
Yo acabo de hablar con el señor Abdullah y creo que vamos a proceder a aceptar un convenio declaratorio.
All right. Let's begin with the plea hearing. All right. Mr. Serrato Paz, may I place you under, or Paz Serrato, may I place you under oath?
Señor José Paz Serrato, ¿puedo juramentarlo?
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
¿Usted jura o afirma que la declaración que dará será a su mejor saber y entender?
Sí.
I do.
Thank you. Mr. Abdullah, what's the plea offer for the expired license, brake light violation, and giving false information?
¿Cuál es el convenio declaratorio por falta de licencia de conducir, incumplimiento del uso de la luz y por dar información falsa a un oficial de la fuerza del orden?
For the stated charges, the state is recommending 11 months and 25 days with 12 days to serve, credit for time served, 6 days, balance suspended.
I'm sorry, 25 days to serve. What was after that?
No, it's 11 months and 25 days.
Yes, 11 months, 25 days, 25 to
Yeah.
serve, and after that?
12 days to serve and credit for time served, 6 days.
Thank you.
And the balance is suspended.
Thank you. El convenio declaratorio se trata de una sentencia de 11 meses, 25 días, a servir 25 días. Para servir 12 se le da crédito por los 6 días ya servidos y el resto de la sentencia queda suspendida.
Okay. My Spanish is definitely about 0.01%, but I just want to confirm. Madam
Yes.
Interpreter, the sentence is for 11 months and 25 days. It's not 12 months. Okay.
Yes, 11 meses. Yes,
Okay.
it confuses with 12, which
Yeah.
is 12. Yes, ma'am.
And he serves 12 days and he's given credit 6 days.
Yes, ma'am. Let me repeat
Okay.
it. Just
Okay.
entonces, la jueza quiere clarificar, son de nuevo 11 meses de cárcel y se le da 12 días que ya ha servido, se le da crédito por 6 días y el resto de la sentencia se suspende.
Okay. And anything else, Mr. Abdullah?
¿Algo
That's
más,
all for
señor?
the state, Your Honor.
Eso es
Okay.
todo para la fiscalía.
Mr. Adoris, does your client accept that recommendation and do you stipulate to the factual basis, venue and ID?
El señor licenciado Adoris, él acepta está de acuerdo con todos estos hechos estipulados y a la declaración.
We do, and we do stipulate to the factual basis, venue, and ID for the purpose of this plea.
Sí, acordamos y también con la jurisdicción y la estipulación consiguiente.
Mr. Serrato Paz, have you consumed any medication or alcohol recently?
Señor Serrato Paz Serrato, ¿ha usted consumido drogas o medicamentos recientemente?
No.
No.
Have you understood the proceedings and are you satisfied with your attorney?
¿Usted entendió todo el proceso hasta ahora y está satisfecho con los servicios de su abogado?
Yes, I am.
And if you decide to plead guilty to these charges, you would have to give up your right to a trial before a judge or a jury.
Y si usted desea aceptar declararse culpable ante este convenio declaratorio, usted va a renunciar a su derecho a juicio ante juez o jurado.
To give up your right to confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt.
Usted no podrá carear a aquellos que lo acusan ni citar otros pasos del juicio y también a que se le considere inocente más allá de toda duda razonable.
Are you prepared to give up these rights?
¿Está preparado a renunciar o no usar estos derechos de ir a juicio?
Sí.
Yes.
Is anyone forcing you to take this plea today?
¿Hay alguien que lo haya forzado a tomar esta declaración hoy?
No.
No.
How do you plead to having an expired or no license on person, a brake light or turn signal violation, and giving false information to an officer?
¿Cómo se declara ante los cargos de falta de licencia de conducir, incumplimiento en el uso de la luz de giro y la presentación ante un oficial de la fuerza del orden de un nombre o información falsa?
Guilty.
Guilty.
Your sentence is 11 months and 25 days to serve 12 days, credit for time to serve 6 days. Your jail time is concluded. You should be released unless, well, but you have your other case holding you.
Entonces su sentencia se ordena de 11 meses y 25 días, 12 meses a servir con un crédito otorgado de 6 días y su sentencia queda finalizada, pero usted no podrá ser puesto en libertad porque tiene otro caso pendiente.
Una pregunta.
One question, please.
Yes?
¿Sí?
Para el caso del 2019, yo ya hice 106 días de cárcel. ¿Habrá alguna manera en que pueda pagar, como quien dice, ya con time served y tiempo servido?
Un momento. Regarding the 2019 year case, I actually was in jail for 106 days. Is there any way that I may be able to have a sentence of time served?
No.
No.
Okay.
Okay.
Thank you.
Gracias.
All right, ma'am. We have another case that may need the services of the interpreter, Mr. Sanchez Martin, but I don't know where he is at the present time. But we'll move back.
I'll stand by, Your Honor.
All right, thank you. Courtroom
You're
2,
welcome.
who do we have, please?
This is an add-on. Position 1, Mr. McGee. Oh, I'm sorry.
Is that correct? Is that the add-on?
No. Let me, okay.
Yeah,
This is actually
William McGee.
position- No, the one that's sitting in front of you, Judge, is gonna be position 27, Mr. Williams, Mr. Cloud case.
All right, thank you.
Forgot your term, too.
This is Travis Williams, 22 CR 0085448. Mr. Williams is accused of battery from December 27, 2022. Excuse me, did you say Travis Williams or Tyler Williams?
Travis Williams, position 27.
Good, okay. Mr. Travis Williams, you've been advised of your right to remain silent, and your attorney is Miss Maureen McLeod. Ms. McLeod, this is going to be,
A negotiated plea, Your Honor.
all
My
right, thank you.
client will accept the state's offer.
All right, thank you. Mr. Williams, please raise your right hand. Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Abdullah, what are the terms of the plea offer?
Yes, the state is recommending 12 months with 60 days to serve, credit for time served 14 days, balance probated with 6 weeks anger management, a stay away from 500 McDaniel Street, and no further contact with the victim, Kenneth Harris, common speller.
Ms. McLeod, are those the terms to which your client has agreed, and do you stipulate to the factual basis, venue, and ID?
I do, Your Honor, and that those are the terms of the state's offer as we understand it.
All right. Mr. Williams, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with the attorney you received?
Yes, ma'am.
And is anyone forcing you to take a plea today?
No, ma'am.
If you decide to plead guilty to the charge of battery, you will have to give up your constitutional right to go back to court and have a trial before a judge or a jury. You will not be able to confront your accuser, examine witnesses, have the assistance of an attorney to challenge the state's evidence, present any defenses if you choose to do so, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Are you doing so freely, willingly, and voluntarily?
Yes, I am.
How do you plead to the one count of battery?
Yes.
Your sentence is 12 months to serve 60 days, credit for time served 14 days. After you've completed the additional jail time, you'll be placed on probation. While on probation, I will waive your probation fees up to and including the end of April 2023. While on probation, you will complete 6 weeks of anger management classes and stay away from 500 McDaniel Street and have no contact with Kenneth Harris. If you completed the 6 weeks of anger management classes, your probation will be non-reporting.
Yes, ma'am.
Thank you.
I understand.
That concludes this case. Thank you. 5 North, who do we have?
Position 2 on the add-on, Sanchez.
No, I believe his attorney needs to speak to him in a breakout with the interpreter, Your Honor.
All right. And
That's correct, Judge. Good morning, Judge. My name is Attorney Haley Hudler. I'm here on behalf of John Sperling, who's the attorney of record for this case. ASG Walker is correct. We're just waiting to get put in a breakout room with the Spanish interpreter so I can confirm whether my client would like to accept the negotiated plea.
all right. Miss Champion or Miss
Lewis,
Lewis?
I got it, Judge.
Okay. Thank you. All right. You will see 5 North. You will see a message on the screen to join the breakout room. Madam Interpreter is somewhere here. There she is. Okay. And she will also join the breakout room. Thank you. All right. Going back to courtroom 2.
This is an add-on position 1, William McGee.
This is State versus William McGee, 22 CR 000-572A. And Mr. McGee has been accused of loitering and prowling from February 20th, 2021. Mr. McGee, you've been advised of your right to remain silent, and your attorney is Mr. Doties. Mr. Doties, how are we proceeding?
Yes, Your Honor, this is going to be a negotiated plea, and we do stipulate to the factual basis, venue, and ID for the purpose of this plea.
All right, and Mr. Walker, what are the terms of the offer?
The offer is time served 33 days, balance suspended with a stay away of 4455 Fulton Industrial Boulevard, which is a Valero gas station.
Oh, okay. Mr. McGee, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank
I
you.
do. Yes.
Have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings?
Yes.
Are you satisfied with the legal services you've received?
Yes, ma'am.
Has Mr. Doties gone over the waiver of rights as set forth in your plea sheet?
Absolutely.
And have you understood his explanations?
Yes.
How do you plead to one count of loitering and prowling?
Yeah.
Your sentence is 12 months to serve 33 days, credit for time served 33 days. And you are to stay away from the Valero gas station at 4455 Fulton Industrial Boulevard. If you return to that location, we will welcome you back with open arms.
Okay, yes, ma'am.
That concludes this case. Thank you.
That's the one that's already established. Yeah, I'll get Larry on your bill project. So appreciate it.
Positions 4 and 5, Davidson.
Very good.
Mr. McLean, how are you, sir? Happy New Year.
Good morning, Happy New Year.
All right.
I'm doing well. We have Mary Momman on Zoom. She's on mute. She is the significant other of my defendant client.
Okay. I do see her on Zoom. All right, thank you. This is State versus Frederick Davidson, case number 19 CR 001116Y. Mr. Davidson has been accused of a traffic-related matter from May 23rd, 2018. The charges are DUI, driving under the influence of alcohol less safe, possession of an open alcohol container, and failure to maintain lane or improper lane change. Mr. Davidson, you have a right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney, and Mr. McLean is representing you. Mr. McLean, how are we proceeding with this case today?
I believe Mr. Davidson would like to enter a non-negotiated plea, Your Honor. The issue is the number of days, extra jail days, if any, that would be appropriate.
All right. And Mr. Walker, what are we doing with position 5, the FTA case, 22 FTA 000084?
Your Honor, Naomi Campbell.
Oh, I'm sorry, Ms. Campbell, yes.
Yes, Your Honor. Pursuant to a plea negotiation in position 4, the state was going to be entering a no process in position 5.
All right, thank you. Okay, let's go ahead and proceed with the plea hearing. Ms. Campbell, what is your plea recommendation?
Yes, Your Honor. The state's recommendation is 12 months to serve 90 days, credit for the time served 26 days. The balance is to be probated. He's to do 240 hours of community service. He's to pay a $600 fine. He is also to complete a alcohol, drug, and evaluation and treatment, as well as a risk reduction course.
All right. And does this apply to the DUI?
Yes, Your Honor.
And what are we doing with the other 2 charges? Is that concurrent, or is this a global offer? Are we going to null pros or merge any of the charges?
I would be asking that they merge.
Okay. Possession of open alcohol container, I can do that. Do you want, I'll just do a, and the failure to maintain lane or improper lane change, you need to do something. I can't merge that.
Okay, the state will no process the failure to maintain lane pursuant to a plea.
Okay. Mr. McLean, what is the defense seeking instead?
Last time we were in court, we had a hiccup about understanding about jail credit time, which has now been straightened out. We appreciate that. The reason it's non-negotiated even today, though, is that he wants the court to realize he feels that perhaps the calculation of what would be appropriate from his worthy opponent might be based partly on his failure to appear. And he wants the court to know that his failure to appear in court was, he was having a seizure that day. He had had a seizure before he had gone to the doctor for. This time he didn't go to the doctor, so he has no documentation. That's why Ms. Moman is on to confirm that he did have a seizure that day, went to bed, did not go to the doctor, has no documentation, but that he really didn't mean to miss court that day. And so he would like for the court to see him as a responsible person who would have made court if he possibly could have that day. And he turned himself in once he found out that it was a warrant. That's the second point. So that's A and B. And we're hoping that that moves the state. And if it doesn't, we're hoping it moves the court.
All right. Ms. Campbell, do you have a response? And also, is this a first time DUI?
No, Your Honor, I do have a response to answer your question. The state does believe that its offer is appropriate in light of the history and the facts, and I would like to briefly place both of those on the record. He does have a 2007 conviction for DUI, and there was an ensuing probation violation from that conviction. And as you know, the defense counsel just mentioned, he did FTA on this DUI case. That's why it's such an old case. It's from 2018. And while I do understand that he had a seizure, it looks like he FTA'd twice. So it wasn't just one time. He FTA'd on March the 16th of last year, 2022. He was arrested and then he posted a new bond, and then he FTA'd a subsequent time on November the 8th of 2022. And at that time, his bond was forfeited, and that's why he has a cash only bond right now on this case. He also has a 2009 conviction for criminal damage to property, a 2011 carry and concealed weapon, but the state is concerned about that prior DUI out of all the convictions. And just briefly, the facts are that officers got a call for a possible driver under the influence, and this is the date of May 23rd of 2018. The location was near Haynesbridge Road in North Winds Parkway. And upon arrival, they did observe the vehicle failing to maintain their lane. Upon making contact with the driver of the vehicle, they immediately noticed a strong odor of alcohol coming from his breath and his person. They also observed that he had bloodshot and watery eyes and that he had slurred speech. When he was asked to step outside of the vehicle, he appeared unsteady on his feet. And he told the officer that the last time he had a drink was earlier that morning on the way to work. He did refuse to comply with the field sobriety test instructions. He also refused to give a breath sample. But eyewitness that the officer spoke to did observe this defendant throwing beer cans to the ground near his vehicle before getting into the vehicle and driving it. And search incident to arrest of his person did reveal a Canadian Mist liquor bottle in his left side pocket that was open and half empty. So those are the facts. And so the state does believe that its recommendation is, it is appropriate in light of the prior DUI conviction.
Mr. McLean, do you have a response?
On the 2 dates, the seizure was one of those 2 days. He says he was in a jail cell on the other date. And mainly I wanted Ms. Moman to talk about that seizure. He understands the allegations and probably disagrees with about a third of them, but that's neither here nor there because he's willing to enter the plea and stipulate to the 3 elements.
All right. I'm accepting the state's recommendation to serve 90 days, credit for time served 26 days, the 240 hours of community service, the $600 fine, the alcohol and drug evaluation, as well as the risk reduction matter. In addition to that, while Mr. Davidson's on probation for the 12 months, less the time he served, he would also not be driving. He will have to surrender his driver's license, and he would have to report to probation every month, where he will be subject to random tests for alcohol, because he is not permitted to consume any alcohol while he's on probation. So, Mr. Davidson, we can either go to trial or we can proceed with this plea. What would you like to do?
I would like to proceed with this plea, Your Honor, but all due respect, if you put all this on me at once, you set me up to fail. I would gladly comply with all that you require, but if you pile it all up on me at once, you'd be setting me up to fail.
In what manner would you be set up to fail?
If you pile it all on me at once, I'm 64, I'm on fixed income. It would mean giving 24 hours a day of the rest of my life devoted to trying to clear my name.
I beg your pardon, but if you don't believe that you can comply with probation, I'm not accepting this plea and we can reset.
I will comply.
No, sir. I still don't understand how you are going to be set up to fail. You have 12 months to complete 240 hours community service. You have 12 months to pay off the $600 fine. You have to do the alcohol and drug evaluation. because this is a DUI matter and you have to do a risk reduction. These are the statutory mandates for a DUI sentence. If
Oh,
you
yes.
decide to plead guilty, that are the terms. And I'm
Your
also
Honor-
requiring you not to drive.
Your Honor, he and I
Interrupt,
discussed
but the
all
defendant
the
feels like he needs more
requirements of
time.
the legislature, so he does understand the AD.
If the defendant feels like he needs more time, Mr. McClain, we could do an additional 12 months of probation and could terminate upon completion if he feels like 12 months is not enough for him to satisfy those conditions. So we could do an additional count of the failure to maintain, 12 months probation, terminate upon completion. And if it's completed prior to that, we'll just terminate the probation.
Mr. Walker, I bet he would go for that if we could eliminate the extra jail days.
Are we still negotiating then? Otherwise, I can go on to my next.
That's what the state is willing to do, but that's it.
Understood. I'll explain that to him. He's saying if you want this.
Oh, Mr. McLean, you're not on mute. I can hear you.
I was just repeating what Mr. Walker.
Okay.
So that's okay. So what do you want to do? You want to talk in private? You want to think a couple of days? You want to think a week?
Miss Lewis, is Miss Hudler completed her conversation with her client, Mr. Sanchez? Or could you send them a message ready for
the
them?
breakout room. I can send a message to them.
Thank you. Mr. McLean, how would your client like to proceed?
He's ready to go forward with the non-negotiated plea. He understands what has transpired and he is going to comply. We would ask the court to give him any kind of break it can on probation fees because some of this.
I'm going to waive all his probation fees. He just needs to show up to probation and be available to be tested when probation requires it. He cannot consume any alcohol and he cannot drive.
Very good.
Okay.
No probation fees. Thank you, Your Honor.
This is State versus Frederick Davidson, 19 CR 001116Y. Mr. Davidson, please raise your right hand.
Yes.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do, Your Honor.
Thank you. And Mr. McLean, do we stipulate to the factual basis, venue, and ID as articulated by Ms. Campbell?
We do so stipulate, yes.
All right. Mr. Davidson, have you consumed any medication or alcohol recently?
No, ma'am.
And during the course of this case, have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you or inducing you to plead guilty today?
No, Your Honor.
Do you understand that you have to do so freely, willingly, and knowingly?
Yes, Your Honor.
And you understand also that I'm accepting the state's recommendation. So are you still willing to go forward with this plea hearing?
Yes, Your Honor.
Keeping in mind that your probation fees are going to be waived, but you'll need to report to probation every month. You cannot drive and you cannot consume alcohol while you're on probation.
I
Do you understand? And you understand that if you violate any of the conditions while on probation, that probation will revoke and you will be back in jail to serve out the rest of the 12 months.
I understand, Your Honor.
All right. Mr. Davidson, in order to accept this plea, I have to ascertain that you're freely, willingly, and knowingly giving up your constitutional right to a trial, to confront your accuser, to examine the state, challenge the state's evidence, examine witnesses with the assistance of counsel, to present any arguments and defenses you may have, and to have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
And you're willing to surrender your license while you're on probation?
They already got them.
All right. So, Mr. Davidson, how do you plead to one count of DUI, driving under the influence of alcohol less safe, possession of an open alcohol container?
No contest?
No, it has to be a guilty plea. That was the terms of the offer.
Yes.
Again, Mr. Frederick Davidson, I'm going to ask you the last time. How do you plead to DUI and possession of an open alcohol container?
Guilty, Your Honor.
The charge of failure to maintain lane or improper lane change will be null prost by the state. They will need to submit the proposed order. The sentence will apply to both charges and is concurrent. It's 12 months to serve 90 days, credit for time served 26 days. Once Mr. Davidson has completed his additional time, he will be report to probation. His probation fees are waived. While on probation, he will complete 240 hours of voluntary community service at any nonprofit agency. He will pay a $600 fine. He will also complete an alcohol and drug evaluation and submit himself to any treatment as required. He will also complete a risk reduction program. That concludes his case. Thank you.
Thank you, Your Honor.
Thank
Next, Judge, we have a private attorney case, position 14, McIver. His attorney is Beverly Taylor.
Hey.
You're muted, Ms. Beverly.
Hey.
Okay, good morning. Can you all hear me now?
Yes, Ms. Beverly Taylor. How are you? Happy New Year.
Happy New Year. Happy New Year, Judge. Happy New Year, everybody. I do represent Mr. Anthony McIver. Judge, we're going to enter a plea of not guilty on Mr. McIver's behalf on this case. And basically going to be asked for a jury trial. So,
all right. Would you like to do a waiver arraignment, or would you like to arraign your client? Would you like me to arraign your client?
Judge, we would waive formal arraignment and a reading of the charges, enter a plea of not guilty, and ask for 10 days to file motions in the case.
Understood. Please make sure that you submit your written waiver of arraignment to,
I will.
Miss April Champion. Her email's on the chat feature. It's april.champion@fultoncountyga.gov.
Yes, yes, Judge.
All right. Mr. Anthony McIver, in case 22 CR 008546G, the case arraignment has been waived pursuant to counsel, and the case will be further noticed for jail jury. Thank you.
Judge, and just an aside, I know you may not have anything to do with it. We're trying to get some help on it. Mr. McIver is actually being held on a charge of a misdemeanor charge where pretrial came off the bond. This court, can you help us with that? It's a misdemeanor charge.
Let me go ahead and pull it up first. McIver. On this particular case, a simple assault.
Okay, Judge, he has a bond on a simple assault. I think a $5,000 bond.
I see a $3,000 bond.
$3,000.
And then he has possession and use of drug-related objects. Is that the other misdemeanor charge?
Yes, Judge.
All right, and he had a UJR through pretrial for that.
Yes.
All right. I'll put a $1,000 signature bond through the jail.
All right, Judge. Thank you.
All right, and you need to submit the proposed order to Miss April Champion along with.
Your Honor, I know you already granted its ruling, but for the record, for what it's worth, the state will be objecting to that signature bond. If pretrial came off of it, they came off of it for a reason.
Well, no, and I'll let you know why I'm doing it. The possession use, he's already got a surety bond on the other charges, the felony charges that he's got. This was the only one that was a UJR, and and he's already got a surety bond on the simple assault domestic violence, and the possession and use of drug-related objects is not going to prejudice either side at this juncture.
I understand. Just want to perfect the record, Your Honor. That's all.
Understood. Thank you. All right, Ms. Taylor, we'll expect the 2 documents from you. That concludes Mr. McIver's case. Thank you.
And Judge, the UJR is just a UJR. It's not through pretrial or anything, just a regular UJR.
No, you need to phrase it as a signature bond through the jail. I'm not using the phrase UJR.
Okay, signature bond through the jail.
Right. He already violated the UJR by the subsequent arrest. So
$1,000 signature bond through the jail.
Yeah.
through the jail and email the bond order to April Champion?
Yes, ma'am, as well as your separate waiver of arraignment.
All right, Judge, I'll do that.
Judge, before she goes on that, Ms. Taylor, you're gonna have to put the case, the CP number, because this case has not been accused and we do not have it in state court. So it's gonna have to put the number 22 CP 206978 on the order.
I got it.
Wait, so just to clarify, this is a felony case?
You're right, Mr. Walker, you're right.
Yeah,
You're
this
right.
case is not
This
accused.
is not a state court case. This is a superior court case.
Per Miss Lewis, I think her odyssey is working a little bit faster than mine, but that's what I'm hearing.
Miss Taylor, is that a superior court case?
If it's 22 CP, then it will be Superior Court, Judge.
Yeah, sorry, I can sign as many documents as you send me on that case, and it'll be worth exactly what that paper is worth. Nothing.
Okay.
Sorry. I'm gonna have to vacate. I'm gonna have to rescind that ruling on the possession. I have no jurisdiction.
I thought it was a misdemeanor charge that you could set bond on.
Yeah, but it's under a CP case, so it's a superior court case. You can approach one of the presiding magistrates who are designated superior court.
Okay, I've tried that. Okay, let me see.
Okay, sorry.
Preferably while the state is present.
I'm sorry.
Nothing, Attorney Taylor, nothing.
Okay.
All right, thank you. Thank you for catching that, Ms. Lewis. Okay, courtroom 2, who do we have, please?
Okay. Position 7, Gilbert.
Michael Gilbert is case 22 CR 008492D, accused of loitering and prowling, giving false information to an officer, possession and use of drug-related objects, and criminal attempt to commit a misdemeanor. All right, that's going to be a big question mark right there. From December 23rd and 24th of 2022. Mr. Gilbert, you've been advised of your right to remain silent, and your attorney is Mr. McLean?
Yes.
This is going to be a negotiated plea. Would that be correct, sir?
Let me grab the calendar, Your Honor. What number?
7?
Yes, it is, Your Honor.
All right. Mr. Gilbert, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Campbell, what are the terms of a plea offer?
Yes, Your Honor. The state's recommendation is 12 months to serve 30 days, credit for the time served 17 days. The balance is to be suspended. I'm also asking that he have an instruction to stay away from the incident location, which is 516 Wimbledon Road.
Wimbledon, like the tennis match?
Yes, Your Honor.
Okay, Wimbledon Road. Okay, Mr. Gilbert, I'm sorry, Mr. McLean, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor. He does stipulate to the 3 elements, and he does have this understanding of the plea bargain offered. He wishes to ask the court to accept that.
Mr. Gilbert, have you consumed any medication or alcohol recently?
No, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
Is anyone forcing you to take this plea offer today?
No, ma'am.
And has your attorney explained your waiver of rights?
Yes, ma'am.
Did you have any questions about the waiver of rights?
No, ma'am.
How do you plead to the loitering and prowling, giving false information to an officer, possession and use of drug-related? Well, first of all, is it to all the 4 charges, Ms. Campbell?
Yes, Your Honor.
All right. Possession and use of the drug-related objects and the criminal attempt to commit a misdemeanor.
Guilty, Your Honor.
Your sentence is 12 months to serve 30 days. I'm credit for time served 17 days, which means your jail time is concluded. The balance is suspended. Unless you have any other holds, you should be released within 24 hours. You are also to stay away from 516 Wimbledon Road in Atlanta, Georgia. If you return to that location, we will give you an invitation to come back to jail.
Yes, ma'am.
Thank you.
Position 6, Mr. Gantt.
All right, thank you. And Mr. McLean, you represent Mr. Dennis Gantt?
I do.
All right. Mr. Dennis Earl Gantt, position number 22 CR 0084121, is accused of battery, family violence from June 12, 2021. Mr. Gantt, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean. He's standing in courtroom 2. Do you see him on the screen?
Yes, ma'am.
All right. Mr. McLean, this is also a negotiated plea. Is that correct?
It is, Your Honor.
All right. Ms. Campbell, what are the terms of the offer?
The state's recommendation is 12 months to serve 45 days. Credit for the time served 23 days. The balance is to be probated. He is to stay away from the incident location, which is 3136 Martin Luther King Drive Southwest, apartment C6. He's also to have no further contact with Miss Tamiko Brewster. I will note for the record that is his wife, according to the police report. And he is also to complete the family violence intervention program.
All right. Do I have a Tamika Rooster on the Zoom? Tamika Rooster?
Brewster, I apologize. Brewster.
Repeat that name again.
Tamiko, so it's Tomeko, and her last name is Brewster, Brews.
Oh, Brewster. Okay.
Yes, Your Honor.
Thank you. All right, Mr. McLean, are those the terms to which your client has agreed? And do you stipulate to the factual basis, venue, and ID?
Yes to both questions, Your Honor. He does.
Any comment about staying away from the alleged victim, who is his wife? I'm assuming they are estranged then?
He's going to do that, yes, Your Honor. And I've explained to him about the FBIP, that it is rather lengthy and expensive, and therefore I would ask the court to waive probation fees so he can afford that course.
He does understand that he cannot return to the marital home as well.
Correct.
Okay. Mr. Gantt, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. Mr. Gantt, you do realize that this is a case in which you are pleading guilty regarding battery, domestic violence against your wife?
Yes, ma'am.
Okay. And is she, Tamika Brewster, is she your legal wife? Did you all sign a marriage license?
Yes, ma'am.
Okay, just want to be sure. Mr. Gantt, have you consumed any medication or alcohol recently?
No, ma'am.
And have you, is anyone forcing you to take this plea offer today?
No, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And with the explanations that have been offered to you, are you entering this plea willingly, knowingly, and voluntarily?
Yes, ma'am.
Please understand that you will not have the opportunity to go back to court and have a trial. You will not have the assistance of counsel to confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
You also understand that you cannot appeal from this decision.
Yes, ma'am.
And that you would have to stay away from your marital home, stay away from your wife while you are on active probation.
Yes, ma'am.
All right. How do you plead to one count of battery, domestic violence?
Guilty.
Your sentence is 12 months to serve 45 days, credit for time served, 23 days. While you are on probation, you will complete a domestic violence intervention program. You must begin that program within 60 days of being released. I will waive your probation fees up to and through the end of September 2023. After that, you will continue to report to probation and start paying probation fees from October 1st, 2023 until your probation is concluded. Understood?
Yes, ma'am.
At all times, you are to stay away from 3136 Martin Luther King Drive, apartment C6 in Atlanta, Georgia, and you are to have no contact with Miss Tamika Brewster. If you and your wife decide to initiate contact or want to have contact, you have to consult an attorney and have your no contact order amended.
Yes, ma'am.
Please understand, because it's a conviction for domestic violence, you're also not allowed to possess any weapons or firearms. Understood?
Yes, ma'am.
All right, thank you. That concludes this case.
Thank you. Position 13.
I have attorney Zakiah Watson Cafe representing position 13.
Yes, Judge, and she was
Cafe?
asking for a breakout room with her client and they never got on to now, so I don't know if she still needs that breakout room.
Yeah, I still need the breakout room.
All right. If you'd like to call 404-612-2392.
No, Judge, he's on 5 North.
Oh, I'm so sorry. Okay, I thought he was seated next to Mr. McLean. I beg your pardon. Okay. Miss Lewis, if we can place 5 North and Miss Watson Cafe in a breakout room, please. All right. And courtroom 2, who do we have seated next to Mr. McLean?
Position 8, Hamilton.
Okay. All right, this is State versus Cayman Jamal Hamilton, 22 CR 001340E. Mr. Hamilton was accused of simple assault domestic violence from March 11, 2022. Mr. Hamilton, you've been advised of your right to remain silent, and your attorney is Mr. McLean. This is going to be a negotiated plea. Is that correct?
Yes, Your Honor.
All right. Mr. Hamilton, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Thank you. Ms. Campbell?
Yes, Your Honor. The state's recommendation is 12 months to serve 45 days. Credit for the time served 20 days. The balance is to be probated. As the condition of his probation, he's to complete the family violence intervention program, and he's to have no further contact with the victim in this matter. I have to get the name for the record. He's also to stay away from the incident location, which was 2150 Flat Shoals Road.
Yeah, I know you did. I don't know if you did. You gotta pay. You'll have to have one. That wasn't even murder on the farm.
Oh, all right. If you have the alleged victim's name, I'm just looking at your discovery list.
Yes, Your Honor. Give me.
I have Tanisha Ryan. Is that correct?
That is correct.
All right. Okay. Mr. McLean, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
Your Honor, yes, but he is pointing out to me, he says the bond order in which things were considered was no further violent contact, and that was appropriate to, and he believes it's still appropriate to the relationship. If the inertia from that bond order could be carried forward, then I would not have to put this off a week and get her into court. And we got a baby together.
Ms. Campbell, has your victim advocates consulted with Ms. Ryan?
I do not believe we have had recent contact with her. If you'll just give me one brief moment to double check.
And just FYI, the 5210 Flat Show, oh, excuse me, don't worry about it. Okay.
Sorry for the delay, Your Honor.
While we're waiting on Ms. Campbell to check on the situation with Ms. Ryan, Ms. Watson Cafe, what's the announcement for your client?
We're gonna move forward with the negotiated plea.
Okay, just give me a second. We'll finish this one and then we'll move on to your case. And your client's name, I'm sorry, could you refresh my memory?
Hassan Langford.
Langford, thank you.
Okay, it
That's
looks
position 13.
like we had, I'm sorry.
Go ahead.
We did attempt contact. We were not successful, so.
Well, other than his one-time failure to appear on October 10th.
I was in the hospital.
As I was saying, other than his one-time failure to appear, have there been any other allegations of violence with Ms. Ryan, Ms. Campbell?
No, no, Your Honor, I don't have that at all. I don't have that he has any prior convictions for violence either. He had a simple battery in 2012 that was no pros, and an ag assault in 2012 that was no pros, but that's it. There's no convictions. This will be his first.
So
And
without more, I'm comfortable going with no further violent contact and removing the stay away.
Yes, Your Honor, that's fine.
Thank you, Your Honor.
Okay. All right. So based on that, Mr. McLean, your client accepts the terms and the stipulations?
Yes, Your Honor.
Mr. Hamilton, have you consumed any medication or alcohol recently? And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you or inducing you to take a plea today?
No, ma'am.
Has your attorney explained to you that if you decide to plead guilty today, you would have to give up your constitutional right to a trial, to go back to court with the assistance of counsel, to confront your accuser, examine witnesses, have the state challenge the state's evidence, and have the state to try to prove the charge against you beyond a reasonable doubt?
Yes, ma'am.
Are you freely, willingly, and voluntarily giving up these rights?
Yes, ma'am.
How do you plead to simple assault, domestic violence?
Guilty.
Your sentence is 12 months to serve 45 days, credit for time served, 20 days.
Yeah, and we've talked about the math involved there, Your Honor. And
All
of
right.
course, I would ask the court to consider helping him on his probation fee, because that is, of course, the $35 per session.
Well, he's also got 2 more days to serve at the jail.
Right.
Okay. Once he has completed that additional time, he will then report to probation once he's released at 132 Mitchell Street. He must report to probation. Yes, Ms. Dessa.
I have another case and y'all took the bond because of this case. So I was wondering, can I get my pretrial bond back since I've done completed this case?
What's that case number?
It's the, I don't know the number, ma'am.
Is it a Superior Court or State Court case? Is it a felony or a misdemeanor?
It started out as traffic tickets, and then they ended up turning it into like 6 criminal damages and attempt to flee to elude. But the whole point is y'all took that bond, pretrial took that bond because of this case. So can I get my pretrial bond back so I can get out and report? Because if not, I'm still be here.
I believe his open case is a felony. I don't believe it's down here in state court.
Yeah, it's felony. When I got indicted, it became a felony.
Right, you do need to talk to your felony lawyer about that.
That's your answer, Mr. Hamilton? All right. So, as I was saying, you're pleading, how do you plead? Simple assault, domestic violence.
Guilty.
Your sentence is 12 months to serve 45 days, credit for time served, 20 days. Once you have resolved all matters and there's nothing else holding you at the jail, then you will report to probation to begin your family violence intervention program classes. I will waive your probation fees for the first 6 months while you're on probation for this case. And then after that, you will continue to report to probation and pay your probation fees after the 6 months have lapsed. At all times, you are to have no further violent contact with Tanisha Ryan, which means that you cannot have any physical or verbal altercations with her. That concludes your case. Thank you.
Thank you.
5 North, we are moving on to position 13. This is State versus Nassan Sudan Langford, accused of battery from December 19th, 2022, in case number 22 CR 008-399Y. Mr. Langford, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and you're represented by Ms. Zakia Watson-Cafe. This is going to be a negotiated plea. So, Mr. Langford, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Campbell, what are the terms for Mr. Langford?
The state's recommendation is 12 months to serve 30 days. Credit for the time served, 23 days. The balance is to be probated. He is to have no further contact with the victim in this matter. Her name is Stephanie Daniels, and he is to stay away from the incident location. It actually took place at a MARTA station. So the incident location is 1255 Peachtree Street Northwest. He's also to complete the Family Violence Intervention Program.
Oh, this is not domestic violence, is it?
I'm sorry.
I thought
didn't charge it.
Victim is his wife, Your Honor.
We didn't know at the time. We learned when he told us one day that he was in court and he stated that the victim was his wife. So yes, it is domestic violence, but it wasn't charged as a domestic violence case.
Okay. And I'm sorry, did you want him to stay away from that particular location or all of MARTA? I don't know which one were you asking for, just that one?
Just that location, Your Honor.
All right, 1255 Peachtree Street. Is that 5 Points or Midtown?
Art Center.
Art Center, okay. Just before Lindbergh, okay. All right, Miss Watson Cafe, those are the terms. How's your client feel about that?
I've discussed it with him. He's okay with that. The only thing that we would ask is that the probation fees be waived. It's my understanding, speaking to him, that he's been out of work for quite some time. He's a chef, and due to COVID and restaurant closings, he has not been able to secure employment. His arrest, he was living in his car. And so based on that, we would be asking for the, I'm sorry, I have a cold.
Okay.
We'd be asking for the probation fees to be waived, especially since the Family Intervention Program has fees of $25 to $30 per class. So
I will waive the probation fees up to and including through the end of September, but he would need to continue to report to probation thereafter and start paying probation fees from October 1st. So does he still want to proceed?
Mr. Langford, is that okay?
Yes.
Yes, Your Honor.
All right. Ms. Langford, I can't recall whether I placed you under oath. So out of abundance of caution, please raise your right hand. Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Langford, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you or inducing you to take a plea today?
No, ma'am.
You've gone over the waiver of rights with your attorney, and so please understand that if you plead guilty to this charge, you would have to give up your right to go back to court, have a trial, confront your accuser, have the assistance of counsel so you could examine witnesses, challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 23 days. If you have no other holds, you should be released within 24 hours, and you'll need to report to probation at 132 Mitchell Street in downtown Atlanta. And that would have to be done by next Thursday. While you're on probation, I will waive your probation fees from now until the end of September 2023. From October 1st, 2023, you will continue to report and start paying probation fees. While on probation, you will also complete the 6-month domestic violence program, and you must enroll in that program within 90 days of being released. At all times, you are to have no contact with Stephanie Daniels and to stay away from the Art Center MARTA station. If you're using MARTA, you cannot embark and disembark at the Art Center MARTA station. Do you understand?
Yes, ma'am.
All right, that concludes your sentence. Thank you.
Thank you.
Position, good afternoon, Your Honor. Position 22, Ms. Sensley.
We are addressing position 22, state versus Zyria, Acola, Sensley, 22 CR 007-451E. Ms. Sensley, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney and you're represented by Ms. Maureen McLeod. Ms. McLeod, have you had a chance to speak to your client?
Yes, Your Honor, I have spoken with her and this is going to be a negotiated plea.
All right, thank you. Ms. Sensley, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Abdullah, what are the terms for the charge of simple battery domestic violence?
The state is recommending 12 months with 68 days to serve. Credit for time served, 36 days. Balance probated with the 24-week family violence intervention. Proof of employment, no further contact with the victim, Mario White, common spelling, and a stay away from 207 Harwell Place.
And 68 days, credit for time served, 36 days. So she would have 2 more days to serve at jail?
Actually,
No, we're good. Sorry. Sometimes
Yeah.
I need a calculator. No, you're good. You're good. Thank you. I just realized my brain, the penny just dropped. Okay.
You've been doing good so far.
All right. Ms. McLeod, so your client will be done with jail time and she'll be placed on probation to do a domestic violence intervention program. Show proof of employment while I'm on probation and have no contact with the alleged victim. Are those the terms to which your client has agreed?
Yes, Your Honor.
All right. And do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor.
Thank you. Ms. Sensley, have you consumed any medication or alcohol recently?
No, Your Honor.
And have you understood the proceedings as has been going on so far?
Yes, Your Honor.
Are you satisfied with your attorney?
Yes.
Is anyone forcing you or inducing you to take this plea today?
No, Your Honor.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial where you will not have the opportunity to confront your accuser, examine witnesses, have the assistance of counsel to challenge the state's evidence, present your own evidence or any defenses you may have, as well as have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to simple battery domestic violence?
Guilty.
Your sentence is 12 months to serve 68 days, credit for time served, 36 days. If you have no other holds, your jail time is concluded and you will be placed on probation. You must report to the probation office next Thursday at 132 Mitchell Street in downtown Atlanta. I will waive your probation fees from now until the end of September 2023. So it will be to your benefit to enroll in the classes, the 6-month domestic violence classes, as soon as possible. While you're on probation, you must also show proof of employment, or at least proof that you are seeking employment, with dates and times with whom you've interviewed and so forth. Do you understand?
Yes, ma'am.
You have to have no contact with Mario White. Stay 200 yards away from Mr. White and do not communicate with him in any way, form, or manner. Also, do not return to 207, I think it was Hartwell or Harold Place.
Yes, ma'am.
Okay. Any questions, Ms. McLeod?
No, Your Honor.
All right, that concludes this case. Thank you.
Your Honor, my business before the court today is concluded. May I be excused?
Yes, you may. Thank you very much. Have a good week. Well, a week. It's only Tuesday. Thank you. All right.
Thank you, Your Honor.
Okay. Moving on, courtroom 2. Who do we have seated next to Mr. McLean?
Position 9, Henry.
Okay. Is Mr. Sanchez ready by any chance? No, don't know.
Judge, yes, they had to go back in the breakout room to go over the plea paperwork, so it's gonna be a plea.
All right, thank you.
Did Did I correctly understand that number 9 is not a misdemeanor?
I will find out. This is State versus Shakur Malik Henry, 22 CR 001-052E. Mr. Henry's been advised of his right to remain silent, and his attorney is Mr. McLean. I'm a little perplexed.
On chat, it did say released, and then this morning I was going to talk to him, but then in chat I was saying, and number 9, I think the next response was it's a felony. So was that referring to number 9?
Ms. Campbell, can you enlighten us? Looks like there was a bond order of $5,000 on February 25th, 2022 for failure to appear, I think.
I don't have that as a felony. I just have that he bonded out. He was released from the jail.
Well, we just need an offer then, and
Just a minute. Something going on over here.
We'll get your offer, Mr. McLean. Just give me 1 second, okay?
Judge, that was a bond surrender case.
Okay. Yeah, there was a failure to appear, and he's on a $4,000 surety bond for the 1, 2, 3, 4, 5 charges here.
Okay, is there somebody else we can go to in the interim, and I'll work on getting PD McLean an offer right quick?
All right, thank you.
I think I've got a police report here somewhere.
Yeah, Judge, that's correct. It was he FTA and plus the bond did a surrender on the bonding company.
Okay. So, Mr. McLean, Mr. Walker will send you the details of the plea offer. Your client is currently on a $4,000 surety bond. And there are 5 misdemeanor charges on this calendar from February 24th, 2022. So pending the your conference on the plea offer, I'm going to take up another case. Francois?
Very good. If I have a plea packet here with the police report, I'll be able to talk to him about that, but otherwise it might need to be reset. Thank you.
All right, thank you. You may go back and sit in the gallery, Mr. Henry.
Yes.
Francois, maybe you have another case?
This is gonna be probation 1. Mr. Jones, and he also has a visitor in the gallery.
All right, thank you. My probation officer is Miss Trina Harris, yes?
Good morning, Your Honor. Yes, it is.
Right. Thank you. Miss Trina Harris, will you please raise your right hand? Do you solemnly swear and affirm the testimony you provide for the probation revocation cases will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. First case we're addressing is 14 CR 010561. This is State versus Desi Dexter Jones. Based on a conviction for battery domestic violence. And Mr. Jones, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and you're currently represented by Mr. McLean. Ms. Trina Harris, what is the basis for the state's revocation in this matter?
Yes, Your Honor. Mr. Jones was sentenced to probation back in 2015. He was sentenced to 36 months of probation with Judge Porter. As of today, he has not completed his domestic violence classes. He was recommended from an evaluation to complete an ASA-1 treatment program, and as of today, he has not completed it. He had a court hearing back on May the 10th, 2018 with Judge Porter and failed to report to that hearing. That's why a warrant was issued. As of today, his case has 1 month and 7 days remaining. Probation recommendation is to revoke their remaining balance.
Mr. McLean?
Your Honor, we realize there's no time left to complete the course, but he did want the court to know that he's had significant medical problems that interfered with his completion. He did take the DVIP or FVIP course and got about what percentage of the way through?
I was 4 weeks left on both of them.
He was 4 weeks left on both of them, he says.
And I wasn't able to, I was homeless at the time, Your Honor, and I wasn't able to complete them, but I did make a conscious effort to be there the whole three years. Just at that time, Your Honor, I have Crohn's disease, and I also wear a colostomy bag, Your Honor. And I got pretty sick. But since then, Your Honor, I am enrolled in Davis truck driving school. And I paid $5,000 for my truck driving school. And today is the day that I take my exam to get my Class A CDL. So, Your Honor, I have had no drugs since then, Your Honor. I have grandchildren, Your Honor, and I am making a conscious effort, Your Honor, to educate myself and better myself, Your Honor. And all I'm asking, Your Honor.
When did you enroll in the classes?
I enrolled in the class, which class, Your Honor?
I don't know, the one for which you're taking a test.
The truck driver school test? I enrolled in that class. It was October the 30th, October 28th. And if you can, y'all can call.
So in October of 2022 or 2021?
2022, Your Honor.
You enrolled in classes?
I am enrolled right now, Your Honor. I am enrolled.
And did you go in person to undertake those classes?
Yes, ma'am.
And at any time, did you realize that you had not reported to Judge Porter?
Yes, Your Honor, and I did try to turn myself in.
When was this?
Last year, I tried to turn myself in.
When?
This was November. No, this was this was September, right after my birthday. I tried to turn myself in. They said it was not accepted inmates at the time, Your Honor. I tried twice.
There was an arrest warrant issued on May of 2018.
Yes, ma'am. And at that time, Your Honor, I had an episode where I was sick, where I was hospitalized.
No, I'm not talking about 2018. I'm talking about 2022. At any time, did you go back to probation and say, I am?
I tried, Your Honor, and it was at 34 Peachtree Street. They had moved.
When did you report to probation?
I never reported, Your Honor, but I tried to come down to Fort County to turn myself in, and they turned me away.
Understood. Thank you.
Yes, ma'am.
Mr. McLean, anything else?
That's it, Your Honor. We would ask the court to consider reducing that month.
He has 1 month and 7 days left on his sentence. There's been an extended period of time. I don't think Mr. Jones has made a bona fide attempt considering his probation violations in this case. So I'm going to grant the state's request, revoke his the balance, and have him serve out 1 month and 7 days, which means that he would 1 month and 7 days, which would mean the equivalent of 37 days. So he would be in jail for between 16 to 17 more days. 17, 18, no, it'll be 18 days, excuse me. He has 18 days to serve at the Fulton County Jail, after which this case will be closed and he will have no further obligations.
Thank you, Your Honor.
Thank you. Do we have another probation case?
McCord, probation, position number 2.
I think in that position, Mr. McCord is in accord with the state recommendation, if I understand it correctly.
All right. 16 CR 004851E, State versus Corey McCord, convicted of theft by shoplifting. Mr. McCord, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Ms. Trina Harris, what is the probation recommendation?
Yes, Your Honor. Mr. McCord was sentenced to probation back in 2018 to complete 40 hours of community service and a shoplifting class. As of today, he has not reported to our office. He had a court hearing back on September the 21st, 2018 with Judge Morrison. He failed to report to that hearing, and that's why a warrant was issued. As of today, his case has 5 months and 7 days remaining. Probation recommendation is to continue on probation and to start those community service hours within 30 days once he's released, and to complete that class within 60 days upon his release.
Do you have his current address and contact information?
I do not.
We can get it for them.
All right, if you could please place that in the chat to Ms. Trina Harris. We need his current address, phone number, and email if he has one. I will accept the state's recommendation. We will continue, mark this down as a probation violation. He will continue to complete the terms of his sentence within the remainder of 5 months and 7 days. He will report to probation, and he may want to pay attention to this.
Hold on, stop writing and listen to that. Thank you.
He'll be reporting to probation twice a month, not once a month. And when he reports to probation, he must have completed at least 5 hours of voluntary community service when he reports. Every time you report, you must have completed at least 5 hours of voluntary community service. If you fail to complete at least 5 hours at each time that you report, then your probation will be revoked and you will serve out the rest of the 5 months in jail. You will also complete your anti-theft class within 30 days after you're released from the jail, not 60, within 30 days. This case has been going on since 2018. You've had ample opportunity to resolve these issues. I'm not going to tolerate any more delays. You will continue to report to probation twice a month and until the 5 months and 7 days are concluded. Any questions?
No, ma'am.
If you fail to report twice a month, please be mindful that we will issue a probation warrant. Thank you.
Thank you, Ron. Is that Drive or Boulevard or is their apartment number? Yeah. Okay, is that apartment number?
Next, we have position 10, Jones.
Oh, we had DeAndre Weaver for probation. Is he by any chance there?
No, he's not in court with 2. Weaver is 3 South.
Oh, 3 South? Okay, thank you. And I'm sorry, could you repeat the other case you're already on?
Position 10, Jones.
Jones, okay.
And I also have an offer on Mr. Henry Shakir when your honor's ready.
Okay, let's go with Dustin Jones first, 22 CR 008545J. Mr. Jones, you've been advised you have a right to remain silent, and your attorney is Mr. McLean. Mr. McLean, are we still proceeding with the negotiated plea?
Yes, Your Honor, we are.
All right, Mr. Jones, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Campbell, what are the terms of the plea?
The state's recommendation is going to be 12 months to serve 15 days, credit for the time served. The balance is to be suspended.
All right, thank you. Mr. McLean, does your client stipulate to the factual basis, venue, and ID?
He does.
All right, thank you.
Oh,
Mr.
Your
Jones?
Honor, I apologize. I also was asking for a stay away from the incident location, and that is the Barnes and Noble bookstore located at 2900 Peachtree Road Northeast.
All right. Mr. Jones, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings and what the prosecutor is asking?
15 days time served and a stay away.
From the bookstore at
Guilty
2900 Peachtree Road.
You understand?
Is that what you understood?
For a guilty plea?
Yes. Yeah, but do you understand about staying away from the Barnes and Noble?
Yeah.
Okay.
Is anyone forcing you to take this plea today? Mr. Jones?
No.
Okay. And are you satisfied with your attorney?
Yes, ma'am.
Has your attorney gone over the rights that you would have to give up if you decide to plead guilty?
Yes, ma'am.
Which would include the right to a trial, to confront your accuser, to examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up all these rights?
Yes, ma'am.
Are you entering a plea of guilty freely, knowingly, and voluntarily?
Yeah.
How do you plead to criminal trespass and 2 counts of willful obstruction of a law enforcement officer?
I plead guilty.
Your sentence is 12 months to serve 15 days, credit for time served 15 days, balance suspended. You're to stay away from the Barnes and Noble store on Peachtree Road, 2900 Peachtree Road. If you return to that location, the authorities will arrest you again. Thank you.
Okay. Thank you.
All right, is that Mr. Sanchez at 5 North?
Yes, ma'am, it is.
All right, and Miss Hudler, are we ready to proceed?
We are, Judge. I am, as we speak, I am emailing our completed plea paperwork to ASG Walker.
Okay, so we're not ready quite to proceed then. Okay.
Is there anyone else who I should email it to
April
aside from the
Champion?
state?
April Champion?
Okay.
All right, so while we're waiting on that, we will return to Mr. Henry. Mr. McLean, are we ready to proceed with Henry?
This is not Henry, Judge. This is
Oh, I'm sorry.
position 15 and 16, Mr. Moore. He
Okay.
actually wanted to go pro se if his attorney was not present.
Well, let's find out. This is State versus DeJuan Kenneth Moore. His attorney is Mr. Gabriel Winters. Mr. Gabriel Winters. Okay. Mr. DeJuan Moore is got 2 cases pending before us, 17 CR 02-11655Y, in which he's accused of DUI, driving under the influence of alcohol less safe, obstruction of a law enforcement officer, and speeding from February 14th, 2016. Position 16 is a failure to appear matter. I'm assuming because of the position 15, and that is 23 FTA 000005. Mr. Moore, you've been advised of your right to remain silent, and your attorney, Mr. Gabriel Winters, has not sounded out present. Okay, let me see, 15 and 16. Mr. Abdullah, did you have a plea offer for the DUI case?
Yes, for the DUI case, the state is recommending 12 months to serve, 15 days with credit for time served. I'm sorry, that's 14 days with credit for time served, 7 days, balance probated with the alcohol and drug evaluation and treatment, a risk reduction, the VIP victim impact panel, a $300 fine, and 40 hours of community service. As to the FTA, the state is willing to no across the FTA for a guilty plea on the DUI.
All right. Mr. Moore, typically I cannot proceed because your attorney is not present. You do have a right to an attorney. You do have a $5,500 cash bond due to your failure to appear. I do see that a motion to set aside the bench warrant was filed with the court on December 6th, 2022, before Judge Edie. And that is what your current situation is.
I understand, Your Honor. I would like to continue pro se.
Well, if you choose to proceed pro se, you will be responsible for all your legal decisions. And I don't know whether you've had an opportunity to review the plea offer, how it may impact your situation, any licenses you may have, any open cases, your job, and so forth.
I discussed the situation a couple times with my attorney over the phone. So I'm willing to proceed.
I'm sorry, I didn't understand. You've spoken to your attorney over the phone?
Yes, about the situation.
And does your attorney know that you have a hearing today?
I assume he did, but I guess not.
Ms. Lewis or Ms. Champion, can you inform me if Mr. Winters has been notified of this SAP court date?
Yes, Judge, I'll try to contact him by phone, but yes, he should have been aware of the court date.
The only way I can really proceed, Mr. Moore, is if your attorney withdraws from the case, because I don't know whether he's just not been notified, or have you fired him?
No, I haven't.
Okay, then he's still your attorney and he's required to be present. He's filed all these motions. He's filed a Jackson Deno hearing. He's filed a Brady demand. He's filed motion to suppress. He's done everything that he's supposed to do as a defense attorney. Are you sure you want to proceed without him? Because he's on the ball.
Yeah, this case has been going on since 2016
And you did not appear in court. So it's not, the delay is not necessarily because of how long it's been.
yeah, Your Honor, I was incarcerated a few times. Yeah.
Okay. So I would highly recommend that you wait for your attorney to appear and let him proceed.
Okay, the plea deal, it was just time served, but there would be an impact to my license. That's why I said,
A DUI conviction can have an impact on your driver's license, on your job, on any open cases, on any professional licenses you may have. It could impact your residency if that's applicable to you. So, and you will need an attorney to advise you of this kind of negative impacts.
so I cannot continue at all. I should just, it's non-negotiable to continue. It's a firm decision.
I can reset it for this Thursday, but I'm going to just put you on ice right now and wait for your attorney to see if he appears.
Okay.
Thank you. You may go back to the gallery. Next case, please. Ms. Champion, do you have the plea paperwork for Mr. Sanchez?
Yes, ma'am.
All right. Ms. Hudler, we're ready to proceed. And okay, this was our add-on case, yes?
Yes, position 2, I believe, Your Honor.
Yes. All right, our interpreter has been sworn. This is State versus Diego Sanchez Martinez, case number 22 CR 008463B.
Este es el caso de Diego Sánchez Martínez, número 22CR008463B.
Mr. Sanchez Martinez is accused of battery, domestic violence, and disorderly conduct, allegedly from November 22, 2022 in Fulton County, Georgia.
I'm sorry, can I have the date again, Your Honor?
November 22nd in year 2022. Lots of twos.
Yes. Los cargos pendientes en este caso es de conducta negligente y violencia familiar con golpes y lesiones ocurridos el 22 de noviembre del 2022.
Mr. Martinez, you have a right to remain silent about the facts of your case. Anything you say about the facts, your statements can and will be used against you. You have a right to an attorney and your counsel is Ms. Haley Hudler.
Señor Martínez, usted tiene el derecho a guardar silencio acerca de todos los hechos de su caso, pero si usted desea relevarlos, usted puede, esa información puede y será utilizada en su contra. Tiene derecho a recibir la asistencia de una abogada y la abogada que lo está representando es la señorita Haley Hudler.
All right. This is going to be a negotiated plea, so I need to place Mr. Sanchez under oath.
Esto va a ser un convenio declaratorio. Necesito que el señor Sánchez, por favor, levante su mano para ser juramentado.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
¿Usted jura o afirma que la información que declarará será la verdad y toda la verdad a su mejor saber y entender? I do. Yes.
Mr. Walker, what are the terms of the offer for the battery, domestic violence, and disorderly conduct?
¿Cuál es el del convenio declaratorio para el cargo de conducta negligencia y violencia familiar?
To the disorderly conduct, it will be 11 months, 28 days, to serve 40 days, credit for time served 20 days.
La sentencia es de 11 meses con 28 días a servir 40 días y se le otorgará crédito por 20 días.
Balance probated with the conditions of FVIP and no further contact with the victim, Rosario Garcia.
el resto de la libertad probatoria va a requerir un programa de intervención de violencia familiar y no tener más contacto con la víctima Rosario García.
To the count of battered family violence, it will be 6 months probation to run consecutive to the disorderly conduct.
Y para el cargo de violencia familiar, la sentencia es de 6 meses de libertad probatoria que se cumplirá de manera consecutiva con el cargo de conducta negligente.
Probation may terminate upon completion of all conditions.
Y una vez cumplidas todas las condiciones de esta probatoria, esta sentencia acabará.
Judge, are you with us?
Yes, I'm oh,
Okay, we can't see you.
I'm sorry. I didn't realize I clicked that. Sorry about that. Okay. Yes, I'm here. I heard everything. And Miss Hudler, does your client accept the terms and do you stipulate to the
Señora abogada Hadler, ¿está de acuerdo su cliente con todo esto y está a usted llegado a un acuerdo con la fiscalía en esto?
I'm sorry, does your client stipulate to the factual basis, venue, and ID?
Él está de acuerdo con la información de la jurisdicción y también con todo lo relacionado en su identificación.
We do stipulate, Judge.
Sí, su señoría.
Mr. Sanchez, have you consumed any medication or alcohol recently?
Señor Sánchez, ¿ha consumido usted alcohol o medicamentos recientemente?
No.
No.
Have you understood the proceedings so far?
¿Usted ha entendido los pasos de este proceso hasta ahora?
Sí.
Yes.
Are you satisfied with the services of your attorney?
¿Está satisfecho con los servicios de su abogada?
Sí.
Yes.
Is anyone forcing you or to take this plea offer today?
¿Hay alguien que lo haya forzado para tomar declaración aquí hoy?
No.
No.
Has your attorney explained to you by taking this plea, it may affect your residency status?
¿Le ha explicado su abogada que al tomar esta declaración podría afectarle a usted su estado de residencia?
Sí.
Yes.
Are you satisfied with her explanation?
¿Está usted satisfecho con la explicación de ella?
Sí.
Yes.
Has your attorney explained to you that if you plead guilty, you would have to give up your right to a trial?
Le ha explicado su abogada que si usted toma una declaración de culpabilidad, usted no tendrá derechos de ir a juicio?
Sí.
Yes.
You will not be able to go back to court, confront your accuser, examine witnesses?
¿Usted entiende que no tendrá el derecho de carear al juez o a quienes los acusan en un juicio?
Sí.
You
Yes.
will not have an attorney to help you challenge the state's evidence and present your own defenses?
¿Entiende que usted no tendrá el derecho de que lo asista un abogado para que lo defienda de los cargos y tampoco de el convenio declaratorio de la fiscalía?
Sí.
Yes.
And you will give up your right to have the state try to prove the charges against you beyond a reasonable doubt?
Y usted no va a usar el derecho a hacer que la fiscalía compruebe su culpabilidad más allá de toda duda. ¿Entiende?
Sí.
Yes.
How do you plead to one count of battery, domestic violence, and one count of disorderly conduct?
¿Cómo se declara usted ante un cargo de golpes y lesiones, violencia familiar y un cargo de conducta negligente?
Sí,
¿Cómo se declara?
Culpable.
I plead guilty.
For the disorderly conduct, your sentence is 11 months and 28 days.
La sentencia será por conducta negligente de 11 meses con 28 días.
You will serve 40 days and be given credit for 20 days.
Usted va a servir 40 días recibiendo crédito por 20 días.
Once you're released, you will be placed on probation.
Una vez que se le dé libertad, usted estará bajo libertad probatoria.
Within 30 days of being released, you will enroll in a domestic violence intervention program, which is a 24-week program.
Una vez que lo pongan en libertad, usted tendrá 30 días para registrarse a cumplir un programa de intervención de violencia familiar. El curso es de 24 semanas.
For the battery domestic violence, the sentence is consecutive. That means it will start after the disorderly conduct sentence is over.
Por el cargo de violencia familiar, la sentencia es de 6 meses a cumplirse de manera consecutiva. Quiere decir que cuando usted termine de cumplir con el cargo de conducta negligente, esta sentencia habrá sido cumplida.
You will be on probation for an additional 6 months.
Entonces estará usted bajo libertad probatoria por 6 meses adicionales.
And that probation may terminate. The 6 months additional time of probation will terminate if you completed all the conditions.
Y esos 6 meses de libertad probatoria terminan si usted completó todas las condiciones colocadas en esta libertad probatoria.
At all times, you are to have no contact with Rosario Garcia.
En todo momento, usted no debe tener más contacto con Rosario García.
Okay.
Do you have any questions about your sentence?
¿Quiere hacer alguna pregunta acerca de su sentencia?
Todo estoy de acuerdo.
I agree with everything.
All right. Ms. Hubler, any questions?
Yes, Judge, briefly. Judge, it's from the way that you just read the sentence, it sounds like you did this already, but I did want to confirm that the sentence sheet, please itemize with specificity each charge with each length of sentence.
Mm-hmm. So Ms. Champion will fill out on the disorderly conduct that for the disorderly conduct, which I think is count 2 or count B, it would say 11 months, 28 days. And then for the battery, it would say 6 months consecutive.
Perfect.
And I will take a look at it. And I understand why it's being framed that way.
Thank you, Judge. Would it be possible for me to review the sentence as well? If not, that's fine.
So no, that's fine. Ms. Champion, if you can put your email to Miss April Champion.
Yes, I can do that.
All right.
And Judge, I did have another follow-up question regarding probation.
Okay.
My client is, I have discussed that with him, the possibility that a plea here to this case would result in his deportation because of his immigration status. And so I wanted to address how we would handle probation if he were to be deported.
Well, if he's in removal proceedings, it would be difficult to comply with probation. If he does a program like that in another country, he would need to obtain a certificate and send it to the probation office in Fulton County to see if they will accept it. It's got to, it's just
Okay.
I mean, there's no reason not to give due recognition to a qualified school in another country. So, and that's what he's required to do, a domestic violence intervention program.
Okay, so he would, rather than suspending the probation and reinstating if he returned to the United States, we would just have him report remotely from Mexico.
Yes, Ms. Hudler, you would need to make sure you notify probation and let us know that he is otherwise removed so that the probation can request the court to amend it to telephonic reporting. Or I can put in the disposition sheet that in the event that Mr. Sanchez is deported, then we will allow him to report telephonically.
If the court could provide that in the disposition sheet, that would be wonderful. Thank you.
Well, Mr. Walker, any objection to telephonic? I don't. All right, only in the event. It has to be a contingent proceeding, okay?
Yes, Your Honor, thank you. And will it be possible to get his probation officer's contact information today?
You're right now, if you look at the Zoom on the participants, we have Mrs. Thomas _ JCS probation. If you want to chat with her, you will be able to get the information from her.
Perfect. Thank you very much. I will email Ms. Champion to get a copy of the sentence and stay on the line or to contact Ms. Thomas as well.
Sounds like a plan. Thank you, Ms. Hudler.
All right. Thank you, Judge. And once I handle that business, may I be excused? That's my last case on the calendar.
Certainly. Thank you.
Great. Thank you.
And may the interpreter be excused? Your
Yes, thank you very much. Appreciate your
You're very
time.
welcome.
Thank
Have
you.
a good day.
All right. Thank you, Mr. Sanchez. That concludes your case.
All right, thank you.
Thank you.
Judge, going back to position 15 and 16, their attorney is present.
Yes, thank you. Mr. Winters, good morning. Is it still morning? Yes, it is.
Hey, good morning, Judge.
right.
Apologize for being late. I
No,
never
that's quite
received,
all right.
I
We're
never
glad that
received
you're here.
notice. Yeah, I'm
So,
pulling around the side of the road right now.
Okay, so Mr. DeJuan Moore is in the courtroom. If you, I don't know what kind of device you're using, but if you scroll, you should be able to see courtroom 2.
Yes, ma'am. Yes, Your Honor.
Okay. And he does have the 5,500 cash bond on the DUI case due to a failure to appear. And I do see that you have already filed a motion to set aside the bond forfeiture, which is before Judge Edie.
Yes, Your Honor.
So that would be a matter that has to be addressed with Judge Edie. Mr. Abdullah is on the Zoom as well, ASG M. Abdullah, and he has a plea offer, which he'll be glad to send you in the chat if you'd like to review it. Or
Judge,
we can reset it for a plea hearing.
We can do that. I don't have the evidence in the case. I would need to talk to my client in person before entering any type of plea. You know, it looks like you've got 2 plea offers on the same case.
Well, on the second case is the FTA. It's a case that's created due to the failure to appear. So
and that was an oversight. The state is one with the lesser offer, to clarify.
Okay.
Judge, yeah, I wouldn't be able to advise my client whether to enter a plea today or not. I haven't had proper time to consult with him.
I'm going to give you a phone number then. It's the number directly to the courtroom 2 at the jail, 404-612-23. Sorry, whenever you're ready.
Well, Judge, I haven't even received the evidence yet. So.
No, I just need you to confer with him. He was going to waive his right to counsel and proceed self-represented. So.
I'm sorry, say it again. He wants to move forward self-represented.
That's what he initially, when you didn't appear. So I'm glad that you did appear. So
yeah,
404-612-2392.
Come on, Henry.
And we're going to let you speak to him, and I'm going to reset the case to next Thursday.
Okay.
If I could, while the attorney is on.
Next Tuesday. I'm so sorry. Next Tuesday.
The discovery has been uploaded to the e-file where you filed your entry at. So you can find the discovery there.
Okay.
Position 15 and 16 are going to be reset to January 17.
At 9 a.m.
Mr. Winters, did you want to remain on the Zoom, or did you want to just call the jail cell?
Yes, I will call him. Thank you.
Okay, thank you.
The only thing, Judge, with that, we're getting ready to start interviewing for misdemeanor, Judge Law. The phones are gonna be tied up.
All right, Mr. Winters, you may have to do a personal visit then. Thank you. All right, moving on to
Mr. Henry.
Mr. Henry. And this was Miss Watson Cafe's client?
You're not right.
Oh, no, I'm sorry. This
Client.
was Mr. McLean's client, yes?
Yes, Your Honor.
Okay. And Mr. McLean, have you, this is position 9. Have you received the plea offer and what are we doing?
We have discussed it among the parties and he wishes to go forward with the negotiated plea, Your Honor.
Okay. This is 22 CR 001052E. Mr. Henry has been advised of his right to remain silent and counsel. May I place him under oath for purposes of the plea? Do you
Yes.
solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Campbell, he's been accused of giving false information to an officer, false report or application for driver's license, DUI, driving under the influence of alcohol per se, illegal stop standing where prohibited, and DUI, driving under the influence of alcohol less safe. Which charges are we proceeding?
Your Honor, we are going to be proceeding on the DUI per se. And we're also going to be proceeding on the illegal stopping, standing, or parking where prohibited, as well as giving a false name, address, or birthday to a law enforcement officer. And the state is willing to no pros the driving under the influence less safe count, as well as the false report count.
All right, so it'll be the remaining 3 charges. And what's the plea offer?
The plea offer is 12 months to serve 16 days, credit for the time served 8 days. The balance is to be probated. As conditions of his probation, he is to pay a $600 fine. He's to complete 40 hours of community service. He's to complete a risk reduction course, a victim impact panel, as well as alcohol, drug evaluation and treatment. And that's to run concurrent on the 3 counts that the state is proceeding on.
All right, thank you. Mr. McLean, are these the terms to which your client have agreed, and do you stipulate to the factual basis, venue, and ID?
We do so stipulate, and we did discuss those terms. That is our understanding of the terms. We went into a little further detail and talked about the expense of each one, the possibility of conversion on fines, the surcharges, that sort of thing. Thank you.
Where are you planning to seek modification?
No, we weren't.
You will not.
We just
Okay.
discussed everything. So
Okay.
it's not asking to convert the fine. I didn't want him to surcharges.
Okay. Mr. Henry, have you consumed any medication or alcohol recently?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
Are you satisfied with your attorney?
Yes, Your Honor.
And is anyone forcing you to take this plea today?
No, ma'am.
Has it been explained to you that pleading guilty to DUI can have an impact upon your driver's license, as well as your residency status, if applicable, as well as any other open cases or job applications you may have?
Yes, ma'am.
And are you still freely, willingly, and not voluntarily proceeding with this plea?
Yes, ma'am.
If you decide to do so, you would have to give up your right to a trial, to go back to court, to confront your accuser, examine witnesses, have the assistance of counsel to challenge the state's evidence or present any evidence of your own or any defenses you may choose to have. You also have to give up your right to have the state, the prosecutor, try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to DUI, driving under the influence of alcohol per se? That is, driving under the influence with a concentration of 0.08 grams or more within 3 hours or more. Giving false information to a law enforcement officer, and illegal stopping or standing where prohibited.
Guilty.
Your sentence will be concurrent to all 3 charges. The remaining 2 charges will be null prost. The sentence is 12 months to serve 16 days, credit for time served 8 days. If you have no other cases holding you at the jail, then your jail time is concluded and you'll be released within 24 hours. You will report to probation next Thursday at 132 Mitchell Street, where you will then begin the conditions of your probation. And this includes paying a $600 fine plus any surcharges, completing 40 hours of voluntary community service with any nonprofit agency, completing a risk reduction program, completing one victim impact panel, attending one victim impact panel, and submitting yourself to an alcohol and drug evaluation with a qualified provider, and submitting yourself to any treatment that is required. I will waive your probation fees for the first 5 months, but after that, you will continue to report to probation and start paying probation fees. Do you have any questions?
No, Your Honor.
Thank you. Please be mindful that your license may be suspended, so you may not be allowed to drive, and you will need to await completion of the sentence before seeking reinstatement. Thank you.
All right, Judge, we're completed here in courtroom 2.
All right, thank you very much. I don't know if I have other cases, so Mr. McLean and Mr. Doties, are we completed with all your cases?
Your Honor, I have one more probation, I think, Mr. DeAndre Weaver. I sent the paperwork off, so Ms. Harris can tell me if we need to do anything else.
Francois, can they sign on from a different courtroom? Mr. Doties or Mr. McLean?
No.
Okay.
I mean,
Well, I don't have Mr. Weaver anywhere chiming in right now. So give me a few moments, Francois, to just go over the calendar.
Okay.
On the probation calendar, position 1, Jones, revoked 1 month, 7 days to serve 18 days to complete the revocation. Position 2, McCord, is to continue on probation. Position 3, Weaver, is pending a reset to next Tuesday if we don't address him today. If we don't address him today, he will next be addressed on January 17th, 2023. On the add-on calendar, on McGee and Sanchez, both were pleas. On the main calendar, position number 1, Allen is reset 2 weeks to January 24th. Position number 2 is reset, that same defendant, reset to January 24th. Position 3, Brewer, was supposed to be a negotiated plea. Larry Brewer. Mr. McLean, what do you want to do?
Plea, Your Honor, we didn't get to that yet.
I'm sorry, excuse me, Judge. I don't mean to interrupt. I was not aware for position 15 and 16, Mr. Moore. They're deciding to go ahead and take the plea today. Is that correct? Or are we moving forward with that or reset?
Mr. Winters, please come on, please.
Yes,
Mr.
Your Honor,
Winters,
that's correct.
the only problem is I don't have the paperwork. Your client needs to go over the paperwork, needs to check mark the appropriate responses and sign off on them. I can reset him to this Thursday.
Okay.
At
Yes,
9
Your Honor.
a.m. to go over the paperwork, make sure it's completed. And you would need to appear at 9 a.m. and submit the paperwork to the court so that we can move forward with the plea offer.
Okay.
All right.
Yes, sir.
So position 15 and 16 are going to be reset to January 12th.
Excuse me, Judge, can I let Mr. Winter know that he can use the same link that he's using now for Thursday, and he can send that plea paperwork over to me, Katrina Lewis. I will send you a plea paperwork and you can send it back to me once it's completed. So we'll have it already for court for Thursday.
And are you sending it by email or are you going to put your email in the chat? That would help.
I'm gonna send it to him by email, your email.
Okay, thank you.
Everything email.
Excellent. Courtroom 2, again, position 3, Larry Brewer. Mr. McLean, what's the status on Larry Brewer?
If Mr. Brewer is present, that's ready, Your Honor, and that's a negotiated plea. I also have positions 11 and 12 marked. As I didn't check those off.
So position 3 is Larry Brewer and you're ready with a plea. Okay,
Yeah.
Moving on, position 4 and 5. Frederick Davidson was a plea. Position 5 was null pros. Position 6, Gantt was a plea. 7 and 8 were pleas. Position 9, Henry was a plea. Position 10, Jones was a plea. Position 11, Keon Kendrick.
And that's a negotiated plea if he's available.
Is well, you'll be the best person to know if he's behind you.
I don't think he's behind me. Is he on another floor?
He's on 3 South. I don't know if there's an officer up there with a phone.
No one has chimed in. So
Yeah.
okay, I'm gonna reset Keon Kendrick. Is this a time served plea?
Yes, Your Honor, I believe it is.
All right, we're gonna reset it to January 12th, this Thursday, for the plea.
In Odyssey, it says he's loaned out to Grady. I don't know if that's accurate.
In past weeks, he's been loaned out to Grady, Marshall's, whatever, but yesterday he was in the jail and we were able to talk. That was great.
Okay, January 12th for the plea then, because I don't see him anywhere. That will be the same announcement for position 12, same defendant.
Right.
Keon Kendrick. Position 13 was a plea, 14 was further notice for jail jury. 15 is reset to January 17. That's, excuse me, January 12th. January 12th. 15 and 16, that's Mr. Winter's case. Position 17, Page was a plea. 18, Jeremiah Rivera. Is that Mr. Doty's case?
Yes, Your Honor. He indicated yesterday that he wanted to hire private counsel, so I'm just requesting a reset for that.
Okay, reset to January 17th, and he would need to appear with private counsel.
Thank you, Your Honor.
Position, that would be the same information for position 19, same defendant. Position 20, Salam was a plea. 21 was null pros. 22 was a plea. 23, Serrato, attorney waived arraignment and further notice for jail jury. 24 was a negotiated plea. 25, Tillery was a plea. 26, Wiggles was a plea. 20, was Wiggles a plea? I felt like we went round and round. Oh yeah, we did. Okay.
It was a reset to a bench.
No, we
trial,
set it
Your
for a
Honor.
bench trial.
Oh, reset for bench trial. Okay. That's what I thought. 27, Williams was a negotiated plea. 28, Tyler Williams was a negotiated plea. All right, going back to position number 3, Mr. Brewer. Mr. McLean, is your client in the courtroom?
I believe he's on, what floor? He's on 3 South as well?
All right, last call out for 3 South. All right, we're gonna reset this to, was this gonna be a time
You gotta
served?
give the officer some time to get there, because he's by himself today.
Oh, okay.
Yeah, so just give him some time to get there.
Okay, so I'm gonna wait on position 3 and 11.
And Your Honor, I believe Mr. Weaver on the probation revocation calendar, position 3 is on 3 South as well.
Oh, okay.
I spoke with him yesterday and I sent my paperwork to Ms. Harris, so I'd like to resolve that today. So if we can wait for him as well.
All right, so we'll be in recess. Unfortunately, Mr. McLean and Mr. Doties, you will have to remain on the Zoom in courtroom 2. So if you can mute the screen, I know there's a lot of activity. They're getting ready for the next proceeding. So, and otherwise, we'll be in recess until 3 South logs in and we can address Larry Brewer, Keon Kendrick, position 11 and 12, and Mr. Weaver from the probation calendar. Thank you.
Judge, 3 South is coming on now.
Mr. Doties, Mr. McLean, We have 3 South that's logged on. Oh, they can't hear me.
Fit right in? Yes, sir.
All right. Mr.
Position,
Doties? 3 South, good afternoon, right at the strike of 12 noon. Thank you very much. Hello.
how you do?
Fine, thank you.
Position 3, Mr. Brewer.
Thank you, sir. Okay, we have Larry Brewer, who's appearing at the 3 South location at the Fulton County Jail. Mr. Brewer, my name is Judge Law, and we're going to address your case, which is 22 CR 008534B, in which you have been cited and accused of criminal trespass and violation of certain rules at a bus, rail, or station from December 27, 2022. Mr. Brewer, you have a right to remain silent. Anything you say in your open court, your statements can and will be used against you. You have a right to an attorney, and your attorney's name is Mr. McLean. Do you see Mr. McLean on the screen? He's waving his arm at you. Do you see him?
Ma'am, yes, ma'am. Good morning. Good evening, ma'am.
Good afternoon, sir. Okay. All right, this is going to be a negotiated plea. Mr. Brewer, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Ma'am, yes, ma'am.
Thank you. Ms. Campbell, what is the plea offer?
Your Honor, the plea offer is going to be 12 months to serve 14 days, credit for the time served 14 days. The balance is to be suspended.
Is this a MARTA situation?
Yes, Your Honor, it is a MARTA. And I would also ask that he comply with all active MARTA suspensions. He has a 365-day suspension through MARTA.
All right, thank you. Mr. McLean, has your client accepted these terms, and do you stipulate to the factual basis, venue, and ID?
He has, and we do.
Mr. Brewer, have you consumed any medication or alcohol recently?
Ma'am, no, ma'am.
And have you understood what's been going on in your case?
Ma'am, yes, ma'am.
Are you satisfied with your attorney?
Ma'am, yes, ma'am.
Is anyone forcing you to take a guilty plea today?
Ma'am, no, ma'am.
If you decide to take this guilty plea, you will not go back to court to have a trial. You cannot confront your accuser. You cannot challenge the state's evidence, present your defenses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Ma'am, yes, ma'am.
How do you plead to 1 count of criminal trespass and 1 count of violation of certain rules at the bus rail station?
Plead guilty, ma'am.
Your sentence is 12 months to serve 14 days, credit for time served 14 days, balance suspended. Your jail time is concluded. You have to stay away from all MARTA property until your 1-year suspension is over.
Ma'am, yes, ma'am.
Thank you.
You have a blessed day, ma'am.
You too. Thank you.
You're welcome. Position 11 and 12.
Thank you. This is State versus Kendrick, case number 22 CR 007929C, accused of theft by shoplifting and willful obstruction of an officer from September 2nd, 2021. Mr. Kendrick is also accused of criminal trespass from August 17, 2022, in case number 22 CR 008188C. Mr. Kendrick, you have a right to remain silent. Anything you say about the facts of these cases, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean. Mr. McLean, this is a negotiated plea for both cases?
It is, Your Honor.
All right. Mr. Kendrick, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Campbell, is this a global offer or separate plea offers for each case?
Your Honor, it's the same offer for both cases, so it's global. It's just the state's recommendation is time served on both cases.
All right. So it's 12 months to serve how many days, credit for how many days?
I believe it's different amounts on each case. Give me 1 second. So it looks like he served a total of 144 days on the. It's not the criminal trespass. I believe on the criminal trespass.
He's been in custody for 144 days.
Yes,
which
Your Honor.
would encompass both cases.
Yes, Your Honor.
All right. Mr. McLean, are these the terms to which your client have agreed, and do you stipulate to the factual basis, venue, and ID for both cases?
Those are the terms, Your Honor. We do so stipulate.
All right. And Ms. Campbell, were there any stayaways or at this time for both cases?
No, Your Honor, I'm not requesting a stay away.
Okay. Mr. Kendrick, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far for both your cases?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty to the theft by shoplifting, the willful obstruction of an attorney, and of an officer, and criminal trespass, you would have to give up your constitutional rights to go back to court, to have a trial in front of a judge or a jury, be able to have the assistance of counsel to confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am. Yes, ma'am.
Are you entering a plea to both cases freely, willingly, and knowingly?
Yes, ma'am.
How do you plead to theft by shoplifting and willful obstruction of an officer?
Guilty.
How do you plead to criminal trespass?
Guilty.
Your sentence is going to apply to all charges in both cases, and it is 12 months to serve 144 days, credit for time served 144 days, balance suspended. That concludes your cases. Thank you.
Yes.
We have position 3 in probation.
Ms. Trina Harris, last but not least. All right, this is case 16 CR 005-125E, State versus DeAndre Weaver. Mr. Weaver, this is a probation revocation hearing. You have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Dodis. Do you see your attorney on the screen?
Yes.
All right. Ms. Trina Harris is our probation officer who's already been duly sworn, and she's going to testify to the reasons why they're seeking a revocation. Ms. Trina Harris?
Yes, Your Honor. Mr. Weaver was sentenced to probation on June 11th, 2019 to serve, to complete 12 months of probation. All he had was to do random drug screens and pay a fine of totaling $687.50. As of today, Mr. Weaver has not reported to our office with Judge Morrison. His case has 4 months, 13 days remaining. Probation recommendation is to continue on probation. And if he's unable to make that fine, probation does not have an issue of the fine being converted to community service hours.
All right, Mr. Dodis, he can either pay the fine or complete 70 hours of voluntary community service.
Yes, Your Honor. I spoke with Mr. Weaver and he's clear on everything he needs to do. He indicated that he was ready to pay the court fines and surcharges. The amount again, Mr. Weaver, is $687.50. Do you want to pay that, or do you want to do the community service hours?
Repeat?
Pay it.
Okay. This will be marked as a probation violation. I will accept the state's recommendation and continue him on probation. He will report to probation once a month, and once the $687 fine is paid off, probation will terminate.
Okay. And Your Honor, is Mr. Weaver probation fees waived?
Yes. Oh, no, I'm so sorry. No. This is on a revocation hearing. The probation fees are not waived. So the sooner he pays off the fine, the less probation fees he needs to pay.
Okay, so can he waive the previous probation fees from 3 years ago and start fresh on probation fees for now?
Yes,
Okay.
that I will, yes. All right, so Mr. Weaver, right now you owe $687.50. If you pay that off, your probation will terminate and you won't owe any additional probation fees. But the longer you take to pay, your probation fees will start incurring. Understood?
Yes, ma'am.
All right, thank you.
That concludes my business, Your Honor. May I be excused?
Yes, thank you. Mr. Dotis, Mr. McLean, I think that concludes all your cases as well.
It does, Your Honor. May we be
Alright.
excused?
Yes, thank you very much. 3 South, thank you for appearing,
Your Honor.
and we are adjourned. Thank you.
Thank you, ma'am.
All right. April, I'll